All right. Good morning, everybody. Welcome. We've got a lot of ground to cover today, so we're going to get started. First of all, I'll introduce myself. I'm Justice Lee Edmond. The very first order of business was knocking my name placard off the table. So just so everyone knows who I am. We're going to get started. We're going to start with a roll call that Mimi's going to take. But before we do that, let me just urge anyone who is here for public comment, if you would check in with Mimi, because we need a list for our action summary of who the speakers are. I've got a list at this point, and so, but if you have not checked in with her, please do. Okay, Mimi, roll call, please.
All right. Justice Edmond.
Here.
Toby Rothschild.
Here.
Joyce Raby.
Here.
Andrew Arruda. Here. Simon Boney.
Here.
Tara Byrne. Here. Judge Wendy Chang. Here. Abhijit Shaban. Jean Clausen. Johan Drolshagen.
Present.
Margie Estrada.
Here.
Lori Gonzalez.
Here.
Bridget Grammy.
Here.
Andrew Kuchera.
Present.
Joanna Mendoza.
Here.
Kevin Moore.
Here.
Heather Morse.
Here.
Alan Rodriguez.
Here.
Dan Rubens. Mark Tuft. Here. Angelina Valverde. Joshua Walker. Thank you.
All right. Once again, welcome everybody. We appreciate your being here. The one thing I did want to let everybody know is Dan Rice had to resign because of business pressures. He felt that he couldn't continue on the committee, and so I just wanted to publicly thank him for the work that he's done on all of these efforts, and he will not be joining us from this point forward. At this point, we're going to open the floor to public comment, and I'm just going to go down the list, if you don't mind, and tell you who I've got on the list, unless somebody needs a special setting and would like to go first. Let me just say before we start, we really appreciate you folks who are here for public comment. The report that went out from this committee it refers to recommendations, but we've tried to emphasize throughout that these are really just ideas. No votes have been taken on anything yet, and we welcome public comment. We welcome your thoughts. Your input is very important to everybody on this committee. So let me just start by making sure that you understand that's the case. We're going to start then with public comment. Let me just to lay some ground rules. Let me ask you to step up to the table if you would and turn on one of the microphones when you speak. And we're going to give everybody no more than 5 minutes just because there are a lot of, like I said, lots of issues we have to address today. So I'm going to start with, is it Carolyn Shining?
Your Honor, I would like to defer to Mr. Kabatek, and I'll go after. He has some reason.
We welcome Brian Kabatek.
Thank you, Your Honor. I appreciate that very much. And good morning to everybody, and I appreciate you welcoming public comment, and certainly at the same time appreciate your hard work. Anytime we get involved, any of us get involved in volunteer organizations and committees, we know that it's hard work and sometimes can be a little thankless. For those of you that don't know me, my name is Brian Kabatek. I'm the immediate past president of the Los Angeles County Bar. I'm a past president of the Consumer Attorneys of California, and I'm also the chairman of the board of Loyola Law School. So it's those three hats in some respect that I am here in today to comment on specifically the notion of non-lawyer ownership or control in some respects of law firms. And I'm just using that as a shorthand for talking about the issue that we have. So I have 3 points I want to raise with you. The first is I want to make it perfectly clear that someone who's spent more than 30 years of my life in the plaintiff's world, these comments are not coming from the perspective of greedy trial lawyer. Instead, they're coming from my observations in my public service in that particular sector. One area where it would be incredibly dangerous to allow non-lawyer ownership and control would be in the plaintiff's, particularly personal injury area. First of all, not underserved, very well served by very capable lawyers. In addition to that, we have seen in the last decade or so the influx already of hedge fund money that has come into the plaintiff's personal injury practice area, supporting certain law firms. They are chomping at the bit and would be certainly in the position to take over advertising and control of plaintiff personal injury types in cases. The danger in this is that they're beholden to money. They're not beholden to the clients. And my fear, and we see this in some firms already that run and operate as mills, is that they will lose sight very quickly of the clients and their duty to the clients and their protection for the clients. So it would be disconcerting to see any kind of private ownership, a non-lawyer ownership of firms, particularly ones that are moneyed or moneyed interest behind it, in an area that, as we all know, is already well served in the marketplace in California. There are ample, competent, good lawyers, and make no mistake that the area where lawyers and particularly non-lawyers would find the most interest is in the entrepreneurial area of plaintiff's law. So please don't take that as comments of the trial lawyers who are trying to protect their practice, but instead from somebody who understands and knows what the marketplace really is like. The second point I want to make is that if we are truly looking to make litigation easier, more cost efficient, there are other ways to do this. The Chief Justice's Commission on Futures issued a report talking about mid-tier cases and better ways to litigate mid-tier cases. I also serve as a member of the Judicial Council Civil and Small Claims Committee, where last year we worked exclusively on that. I would urge that that work continue, although there's pressure from both the defense bar and the plaintiff's bar not to change what I would call simple civil litigation. Changes need to be implemented as soon as possible. No way that it should cost people $75,000 or $100,000 to litigate a $200,000 dispute in this state. There have got to be ways to get those cases through faster. But I suggest that non-lawyer control or ownership in civil litigation is not the way. I'm no expert when it comes to non-civil litigation. My experience in that is limited. But my last comment today involves the training and the education of lawyers and people in the lawyer marketplace, because I have been the chairman of the board of Loyola Law School for several years. I am dedicated to helping young lawyers learn how to become good lawyers and fine lawyers. And one of the fears I already have today is when a young lawyer either can't get a job or doesn't want to get a job right out of law school, they lose mentoring. They lose the ability to learn the law and learn how to practice law from experienced people. It takes years. Believe me, I graduated over 30 years ago and I'm still learning how to be a good lawyer. And my fear is that bringing people who aren't responsible to either their license with the state bar or to the public in general, or have had that education, will be severely unable to serve the very public that we're trying to protect. So I think there's many ways that we can all work together, the plaintiff's bar, the organized bar, and the law schools, to try to find ways to better serve Californians. So I thank you for your service and I appreciate your time.
Thank you, Brian. Ms. Scheinin, you want up now?
No, I'll take my chances here, Your Honor. Thank you, and thank the task force again. As Mr. Kabatek says, these are, I know, things that have taken considerable amounts of time and energy, and reading through the materials that have been provided and prepared. Again, I want to thank everybody here for doing wonderful public service. I'm going to raise 2 points. One is immunity is forever, and transparency is crucial. I have made public comments in the Daily Journal. I made extensive public comments on the website. I'm a LACBA member of several committees. Also do work with I volunteer with the CAOC. I provided low-cost work for people, both in small businesses, entrepreneurs and their trademarks, conservatorships for people of low and modest means through the LACBA Smart Law program. And I do, as a matter of practice, pro bono work in domestic violence whenever I'm asked to do so. But really, I want to tell you a story, and then I want to ask you for a pledge. The story is, and I'll try and make this as brief as I can, although it goes longer. On a night in Sacramento in 1987 at a dinner at some place called Frank Fat's, there was a very important piece of California legislation that was born. AB 241 was known as the Napkin Deal. It was sponsored by Willie Brown and Bill Lockyer. And at that dinner, there were representatives from industry, doctors, insurance, manufacturers, who carved out and cut together an immunity provision, making very wide, broad immunities. Now, at that time, the medical malpractice provisions of that immunity got all the press. And what was really not focused on at that time was a small couple of sentences that gave broad immunity to people who made sugar, oil, butter, and tobacco. No one thought much of it at the time because at that time we really didn't know a lot. And the tobacco companies were successfully beating people with lung cancer in court by saying, we didn't know. We didn't know it was addictive. We didn't know it was going to cause lung cancer. In the 1990s, as famously portrayed in the movie The Insider, secret documents were revealed showing that that was absolutely untrue. And one of the biggest frauds was committed on the American public that there ever was. To the point of what I'm saying here, that immunity that was provided was immediately repealed when it became clear, but to the California legislature and the attorneys general, that California was not going to partake in the master settlement agreement that the other attorneys general around the country had entered into. We were told by the tobacco companies, sorry, California, you got a deal, you're out. So the legislature immediately repealed that, tried to make it retroactive. They could not. Based on U.S. Supreme Court opinions, when you grant immunity, you grant a right. It cannot be undone. We don't believe in retroactive matters in this country. You cannot undo those things, and you have to be very, very careful. I've heard people talk in this task force about immunity for some of these entities. It really has to be seriously considered. This law has to be studied. It's California Supreme Court opinion from 2002. I'd be happy to give the citations to anybody who needs them. My second point is to ask for something, and this is a big ask. And in no disrespect to Justice Edmonds and Justice Chang, who are Justice and Judge, who I think have the highest integrity imaginable in our court system. However, there are persons who are on this task force who have some things that I think need to be brought out. And I would like to hear a pledge from everyone who's here and everyone who's on committees that deal with these issues in the future to not profit, take salaries, or any kind of benefit from entities that arise from the result of your work. There is a person on this committee who is a member of a company that provides part-time paralegal services online. There's a person here who is an insurance representative who also worked for a major paralegal recruiting company for many years. There's a person here who is in the insurance industry who has said in his bios that he's a professor, but if you go to social media, it shows that he is an employee of a very large insurance company in their risk management department. There's a person here on social media who says they can't wait to disrupt, quote unquote, the legal community in the law of California. There's another person who said on social media, and you can't make this up, quote unquote, describes himself as the robot overlord. These kinds of things really need to be considered and discussed. What we're talking about is important. You grant immunity, you take all these things. My public comments have focused on gender pay disparity and the impact on people who have diverse backgrounds. Those are the people who will be hurt by these kinds of downward pressures on the cost of litigation. People who have struggled and strived to become partners, to get their own businesses, and who face immense pressures against those downward kinds of pressures. So in closing, I want to thank you again all for your time, the efforts that you've made. The principles that you're espousing cannot be challenged. The idea of increased access to justice is an important one. But I think we need to, and hopefully you will consider as you go forward, that immunity is a very narrow issue, but it's very important. Immunity is forever, and transparency is crucial. Thank you so much.
Thank you. Okay, the next name I have on the list is Darian Beaujeau.
Very good, thank you. Well, those are very hard acts to follow. I'm Darian Beaujeau, and I practice in Beverly Hills. I'm opposed to these proposals, and I don't know anyone who's in favor of them. There is a stated goal, which is to make legal services more affordable, but the real result of these proposals would be a lower quality of legal work, lower ethical standards, and legalized capping. And that last one's very important. Legalized capping, that is what would be the result of these proposals. And I think that I understand there is a movement, but I think it's got to be motivated by those who feel that they can profit and can act unethically without having a license to lose. I read that the idea was, well, these non-lawyers could be, their conduct could be overseen by the Department of Consumer Affairs, and I doubt it. And besides, that's been gutted by Trump. And the state bar couldn't do it. The state bar has a hard enough time overseeing anything right now. I mean, maybe if somebody steals money from their client, something will happen, but otherwise, it's case closed. Maybe if somebody agrees that they'll go to ethics school for a day and take a test, and then if they don't do it, I don't even think there's any ramifications. Maybe a little file kept by the state bar. So let's talk about the stated goal. Is there a better way to accomplish that? I would think so. I could see a pro bono certification or award being offered by the state bar if somebody does so much work. And I think that it could come to be that kind of a certification or award could be more valuable than the super lawyer deal. And I think we could have some low-rate clinics, like $100 an hour or $200 an hour of people doing legal work or helping people represent themselves. I think we could have more do-it-yourself booklets, like the ones we already have for the small claims court and simple divorces. And I really think that not just in PI, but in other areas like even probate now and business, you can get a contingency fee attorney if you have a good case and your case is worth litigating. If you're having a hard time getting a contingency lawyer, your case may not be that good, and it may not be as good to throw a lot of money out further. So anyway, Carol told me not to use this word, but honestly, the proposals to me seemed corrupt. They really seemed to me for the purpose to allow capping, and I think they're not well thought out at all. And I would be so disappointed. I mean, there's already a lot to be disappointed about these days. And this would just really add to it. It would be more of what seems to be going on nationally, and we shouldn't have it. We should try to restore the practice of law to ethical standards, and I want to thank you all for your time.
Thank you. Tamila Jensen.
Good morning, I'm Tammy Jensen. And again, thank you for all of your work. I know it's a big commitment of time and effort. I'm the president-elect of Los Angeles County Bar Association, past president of San Fernando Valley Bar Association, and I've been on the legal services, the NLSLA board for more years than I can remember, and past president there. Los Angeles County Bar Association has almost 10,000 dues-paying members, plus an equal number of lawyers and related professionals who obtain various benefits and services from LACBA. 65% of our members are solo and small firm practitioners. On the instruction of President Ron Brodt, we reached out to our membership to seek their input regarding the comment phase of these proposals. And almost across the board, 3/4 of our members did not approve of these proposals as written. That doesn't mean that was universal, but the vast majority of our members are not supportive of these proposals. Our members are deeply committed to access to justice, as I believe are lawyers throughout the state of California. These are the people who volunteer their time and service, work on boards and commission, man clinics, do pro bono service, share their expertise and talents freely. They are where the rubber meets the road. The practice of law is a profession. That means its chief aim is public service. The function of law and the lawyer is to give order, peace, and fairness to society, it has been said. I'm thinking of an old friend, no longer with us, whose great joy was telling people about Henry the Sixth, when the thugs say, first let's kill all the lawyers. What was really happening there was that they were trying to foment a rebellion by taking away the rights of the common people. And the second thug says, well, if we're going to do that, if we're going to take away the rights of the common people, first we have to kill all the lawyers. And he meant that as a way to bring chaos, disruption, and rebellion and remove the king. It has been said that lawyers have three relationships: with their client, with the law, with society at large. And having practiced for a long time, I would add with opposing counsel and other lawyers, and that they find in bar associations. The lawyer's relationship to his or her client is one of trust and confidence on the part of the client, and loyalty and proficiency on the part of the attorney. To that end, in recognizing the crucial role of the law and the lawyer over a long period of time, lawyers and others have come together to create rules, standards, and regulations for the practice to protect the client and the public, but also to satisfy the other goals I've discussed briefly. And so I ask if the proposals before us do these things. And at least from the point of view of the LACMA membership, the answer is generally no. There is support for applying some of these proposals to nonprofit entities to expand their ability to offer services to a greater range of people in different economic groups, to allow them to share fees in order to generate funds to provide these services, to allow perhaps more non-lawyers to offer services through the nonprofit entities, which are highly structured, in my experience, very well managed, and serve tens of thousands of people a year throughout the state of California. So when we look at these proposals, I see a difference between, shall we allow a big corporation to come in and buy a law firm, or offer services without legal supervision. I see a different answer than I see when I say, well, maybe some of these proposals really make a lot of sense to allow the nonprofits in order to do some of this and expand what they can offer. To that end, I'm thinking that the business of business is business. It isn't client service. It's just making money. And we see the problems that can cause. When we relied on Google, Facebook, and others when it first came along, it was supposed to be this, it's a really cool thing. It's going to be this open, and isn't it going to be wonderful? And yeah, sort of it is. And now we've come to realize that their real product is our information, and that it's a very dangerous world out there. So I thank you very much for your time.
Thank you. Mina Sirkin?
Hello, I'm Mina Sirkin. I'm a board-certified specialist in trust, estates, and probate. This is my 27th year in practice. The main problem that I have is I think that these proposals need a lot more thought, a lot more investigation, and I think that the state bar is actually shooting itself in the foot when you allow the category of non-lawyers, which is the rest of the world, to practice law or to provide legal services. That includes a category of people that you disbarred. And those people are all coming back into the practice. They're going to own law firms. They're going to be sharing fees with lawyers. Nobody ever thought about that. That means that your regulatory arm is going to go away, which means that the State Bar of California will implode. So all the people that you employ, this beautiful building that we paid gazillion dollars for, which shouldn't have never been done, is all going to go away. This is the result of not thinking out these proposals. The term non-lawyer means everybody outside of this circle of people that you licensed. And it means everybody that's been disciplined, and disbarred. Everybody that's been disciplined, who's suspended, is now going to be called non-lawyer, and they'll find a law firm to own. They will find legal services to provide. Is that okay with all of you? I think this is the thing that you all need to answer. If capping is illegal, it's illegal for a reason. It's because people are taken advantage of by capping. You have no idea how many times I am approached. I'm a probate practitioner. I'm approached by financial advisors, by realtors, by all kinds of people who want to share fees with me. And if I said yes to any one of them, do you know what would happen? I would end up compromising my judgment. The judgment of a lawyer who can say no is very important, especially when it comes to elderly. I know you guys paid for a report that was done, the Justice Gap report. I don't know too many elderly who use the internet to respond to questions. I don't know how many people actually responded to those queries. And you had about 45 days where you sent out some company back in the Midwest to make inquiries about California residents. And some of the questions that were asked of people were absolutely absurd. What kind of problems do you have? Yes, we have healthcare problems. Those are not legal problems. I don't know how those statistics got mixed into the Justice Gap report, but I think that this needs a lot of thought, and those statistics need to come out and be made public, and how the data was procured. I read that report and I was laughing, because I thought that if that actually went to the legislature, somebody out there would say that those statistics are fraudulently procured. So I urge you to think again. Thank you.
Thank you. Stephen Lash. I'm sure I've got the name wrong.
Losh.
Lash, thank you very much.
Good morning, Stephen Losh. Thank you for having me. I've been a plaintiff's trial lawyer for 56 years. Started when I was 10. But anyway, lawyers work long and hard representing primarily poor people and lower middle class people who are very susceptible to lay people working inside of law firms. I will give you 3 terrible examples and then I'll go. First example happened when I was brand new working in downtown Detroit, and I meet another lawyer who was bragging to me about how wonderful his office manager was, and that he was giving him time to do other things. And every time I'd see him, he would tell me this. Then one day, I see that he and the office manager were arrested for murder. I thought, whoa. I went down to the criminal court and read the file. It seems that his wonderful office manager was taking out life insurance policies on the clients and then murdering them. What saved my friend's butt was that during the trial, the office manager admitted that my friend had nothing to do with this. It was strictly his own idea. And of course, my friend's career was over. I notice he still practices down in some obscure coast city in the state of Florida. The second item was not quite as serious. I had this former friend, and one day he told me that he was up on charges by the state bar. And I said, well, you know, what happened? Well, he says, Steve, I let this guy into my office, a lay person, and he says he just gradually kept assuming more responsibilities. He says, and I thought this was wonderful because it freed up my time, until he found out that the guy had stolen $30,000 worth of client funds and didn't bother to tell him when there were complaints, so that at least he could have given the money back instead of facing a bar complaint. Last but not least, about 14 years ago, I was approached by a New York law firm that needed a California office primarily to enforce judgments by clients that had multiple judgments. So I accepted that responsibility. One day I received a phone call from one of the clients, and he wanted to know what was happening on a current case. That made no sense to me because I had received the funds on that case, sent it to the New York office, which it was kind of disturbing to me. They had quite a few lay people there working in that office. So I asked him if he'd received any checks recently. Oh, yes, he did. It was on an older matter. And I'm thinking, uh-oh, this is trouble. So I called the New York partner, and I started talking to him about this, and I told him, I said, you know, you better look into your records because this looks like a Ponzi scheme to me. I said, somebody's stealing the money, and then when new money comes in, they pay it on the old account, and the client's none the wiser. And then I turned in my resignation because I didn't want to be a party to this. 6 months later, that man committed suicide. And I thought to myself, it must have been an awful lot bigger than I thought. Anyway, thank you very much for having me, and think about what you're about to do.
Thank you. I've got some name down here with JJ, is it? So, thank you.
Hi, my name is JJ. I recently passed the bar a couple years ago. Before that, I was a paralegal for a long time. I was temping, I was clerking, and I used to, sorry, my speech is kind of awkward. I'm not really good at public speaking. Anyways, I used to temp at an office where the attorney was hired, basically. This was probably 5 years ago. Hired by a non-lawyer, so they obviously had a split interest. And the manager would basically speak in another language and hiding things from the attorney, and this was happening right in front of my eyes.
Get the except him. Give me the billable hours on that. Okay.
Oh, sorry.
It sounds like we're getting some feedback from somebody on the phone. So if you are on the phone, would you please put your phone on mute? Thank you.
So after experiencing that and after being in the system for a long time, now that I'm an attorney, after drooling through the bar exam multiple times and finally having my practice, I mean, those things really concern me because those happen right in front of my eyes. And if we allow this, we're basically, I'm here because I've witnessed it, and this big change that we're discussing will probably take us back to what I've witnessed, and that's legitimatizing what's already illegal. And I think we're kind of walking towards that without like realizing what the consequences are. So that's all I have to say today. Thank you.
Thank you very much. Michael Cohen.
Okay, it's on. Good morning, everyone. My name is Michael Cohen. Appreciate all of your work. I know it takes a lot of time to do this kind of committee work, and I appreciate all the work that you've done. Let me give you a little bit about my background so you know where I'm coming from. I graduated from law school in '91. I've been practicing since 1992. I started at a very fancy law firm called Sussman Godfrey doing bet your business litigation. But over time, I migrated to the plaintiff side of the practice. I don't do much personal injury. Most of my work involves suing insurance companies on behalf of policyholders. I also have a substantial amount of legal malpractice cases on behalf of former clients. I agree with the aims that the committee, or the issues the committee is addressing, about people having access to good legal help. I think that's a worthwhile goal, and it's something that we as the profession have done imperfectly and inconsistently over the years. But I don't think that the changes that are being promoted with these ideas are the way to go about it. For instance, again, I'm limited to the context of civil litigation. But if the issue in civil litigation is to give people access to justice, for example, we need more courtrooms, not more lawyers necessarily, more courtrooms and more judges, people to make decisions in these kinds of civil disputes. I don't know whether that's the same in the criminal courts. I don't have that experience. I have some familiarity with the people's backgrounds here, but did anyone here study economics when they were in college? Okay. Well, for those of you who studied economics, this may be familiar. And for those of you who haven't studied economics, you'll learn something new today. In economics, there's a theory called Gresham's law. And it's called the Gresham dynamic. And the notion with that is the bad drives out the good. And where you see that is in marketplaces, where if a major competitor is cheating, then the other competitors have to cheat to keep up. And my concern in having big venture capital money or other big money in the practice of law, that inevitably over time, what will happen is that our commitment to legal ethics and to the notions of justice will inevitably be compromised and be undermined by the profit motive. It isn't necessarily because people are evil, because people are trying to cheat anyone else. It's just inevitably what happens when profit becomes the primary motivation for a transaction. I don't know how many of you read current events, but recently the Business Roundtable adopted a resolution, and they said that corporations now, instead of being governed by the ethic of being principally of responsibility solely to make money for shareholders, that they had other stakeholders in the corporation, employees, members of the community, things like that. And that was adopted by the Business Roundtable about 3 weeks ago. It took less than a week before the first of the major participants in that pledge walked it back and said they're not going to do it. That was Amazon. I'm not being critical of Amazon, but the point is, that was something that was adopted by some of the biggest CEOs in the country for the biggest corporations. But when faced with that possibility that they might have to compromise on the profit motive, they immediately walked it back, less than a week later. And I'm concerned the same thing will happen in the practice of law. I'm not saying lawyers are perfect. As I noted a moment ago, we have been imperfect in our attempts to make sure that everyone has access to legal help. In my own practice, because I have technical knowledge about insurance and insurance policy and claims handling, I probably spend 5 to 10 hours a week giving away free advice to people about how dealing with claims because they're far too small to litigate, but they should have some understanding. I'm happy to do it because I feel privileged to have the knowledge and have the ability to do that and still earn a living. But once you allow the large sums of money from private interests who don't have the same ethical obligation as the attorneys running the law firms, that will inevitably happen. Let me give you an example. Let's say you had, and I agree with Mr. Kabatek, his comments earlier, that among the more attractive areas would be big PI practices of various kinds, whether they're big by volume or probably by volume. What would happen if an insurance company or money that was backed by an insurance fund were to buy a plaintiff's practice or to sponsor a plaintiff's practice and be the money behind it? How long before that would corrupt the judgment of the attorneys who are representing the plaintiffs in those things? And I'm not necessarily saying they'd be ordered to cheat or do anything like that, but simply that over time, that is what will drive the decision making. We've seen it time and again. So while I think the committee is doing laudable work in trying to address the shortcomings in terms of people's ability to get the legal help they need and to get not just access to justice, but to get justice. But I don't think this is the way to do it. Thank you for your time.
Thank you. Olivier?
Yes.
I'm going to let you say your own last name.
Thank you, Your Honor. Olivier Taliou.
Thank you.
Good morning, everybody. Hi, my name is Olivier Taliou. I'm currently practicing as a plaintiff's attorney
at the Dominguez firm, which is one of the largest plaintiffs' law firm, certainly in Los Angeles, possibly in California. I did not start as a plaintiff's attorney. I have a slightly, I think, unique career trajectory. I graduated from law school. I clerked on the federal district court here in Los Angeles, as well as on the Ninth Circuit for Judge Tashima, after which I started working at O'Melveny & Myers, which is a large, what they call big law firm. And just so that I have an understanding, how many people on the panel are involved in the private practice of law? Are there any? Okay, thank you. After O'Melveny, I started a small firm, which became a medium-sized firm involving in commercial litigation. And in the 2000s, I got the tech bug, and I started a technology company for which I raised funds through venture capital and so forth and so on. And then in 2014, I did a complete career change and entered the practice of plaintiff's personal injury work. And I've been focusing exclusively on trial work, almost exclusively on trial work for the last 5 years. So I feel that certainly from a personal experience standpoint, I sort of bridge a lot of the areas that are being involved in the committee's work, which I am thankful for. And like some of the people have spoken before, it's never easy to volunteer. It takes away from your personal lives. It takes away from your professional lives. And we appreciate the time and the effort that you've put in discussing and making these proposals. Just from my sort of organizations that I belong to, or the Association of Business Trial Lawyers. I'm a board member for CALA, the Consumer Attorney Association of Los Angeles. I'm a board member on CAOC, and I've received numerous awards for some of my trial work in the last few years. And I wanted to address one particular aspect of the task force proposals, which relates to the introduction of non-lawyer money into the practice of law, because I do see this as a real threat, not just to the business models of law firms, but to what I believe is our calling as attorneys, and what I believe is the State Bar's calling, which is the protection of the public. I walked into the State Bar building this morning, and I looked at the sign right on the left side of the stairs, and it says the State Bar is a judicial branch agency protecting the public. And I do not believe that introducing private money or non-lawyer money into the practice of law will protect the public. And therefore, I believe that any proposals that come out of the task force that recommend the allowance of private money into the practice of law will actually defeat the State Bar's purpose as stated on the building. So, and I don't want to repeat what some has been said before by very able speakers that have come here, but what differentiates a lawyer, an attorney, from a non-lawyer is that attorney's fiduciary responsibility to his clients. And the concept of a fiduciary responsibility is very unique in the law, and those who practice law understand this, and I'm sure those who do not understand it as well, due to their dealings with accountants, lawyers, doctors, so forth and so on. And the concept of a fiduciary relationship is that as a lawyer, I have to put my client's interests first, before mine. It is a practice that is unique in the field of law. Corporations, profit or non-profit corporations, do not have that responsibility. In fact, they have the opposite responsibility. A corporation's fiduciary responsibility is to their shareholders, not to their clients, not to their customers, not to the public. And therefore, it creates a conflict. And the introduction of private interests into the practice of law creates this conflict. Now, I have the benefit of being the managing attorney of a law firm that represents people all across both economic and also the sort of level of injuries. We have hundreds, if not thousands, of cases involving smaller injuries, for which we have lawyers who diligently pursue these cases. And we have relatively few cases that involve catastrophic injuries. And I am called daily to make decisions on cases that inevitably are against my own firm's best interest. Daily, I have to invest money, I have to spend costs, I have to hire experts, I have to pursue litigation in cases where I know, from my experience, we will never make that money back. But I am that person's lawyer. I signed that engagement letter. I have a responsibility to see the matter through the end. That is a practice, ladies and gentlemen, that will stop the minute a corporation enters the fray. Mr. Cohen made a very good point. Insurance companies will be able to invest in whether it's law firms, whether it's in particular funds who invest in law firms, but insurance companies will be allowed to invest in essentially the practice of law, which inevitably creates a conflict. And even if insurance companies are not allowed, corporations will be able to do so, which will create a corporation versus insurance company dichotomy, which cannot be good for the public. I believe, as an attorney, as someone who's represented corporations, as someone who's represented people, as someone who's represented all walks of life, that every case is different. And one of the advantages of being an attorney and being a skilled attorney is the ability to make decisions based on that one particular case. Venture capitalism and profit-motivated enterprises cannot operate on an individualized basis. I think I'm running out of time. You're looking at me. I know that look. I've been in court, counsel. Let me end with this. I want to talk about, very briefly, alternatives. The State Bar has the power to make attorneys give mandatory pro bono. There's a gap to justice. I agree. Make attorneys mandatory pro bono hours. The State Bar can fund loan forgiveness programs for people who enter areas for the underserved. And again, to sort of piggyback on Mr. Cohen's comment, more judges, more courtrooms, less time between the time a lawsuit is filed and the time a resolution appears. Again, thank you very much for your time. I appreciate the opportunity to speak before you today. Thank you.
Thank you. Alexis, I'm going to ask you to say your last name as well.
Thank you. My last name is pronounced Givray, so another French name in the room.
Thank you.
I'm not going to repeat. I'm going to try not to repeat what everyone else has said today, and I don't have notes. My notes were done on the metro this morning, which had to uncouple some cars, and so I had some time to put it on my phone. I just really briefly want to say that I bet every one of you in this room has probably used an attorney at some point. If you haven't, you will. And the trust that you put in that person is absolute. It's so important. And I started my career in law as a court clerk. And at one point, I was working as a judicial assistant, which is what I was called instead of a court clerk. I was working in a domestic support courtroom. And I can tell you that there were non-lawyers completely surrounding the building that would literally grab onto people and say, I can help you with your case. Come with me into this little room and I will help you. And people thought these people were lawyers and they charged them money to fill out paperwork. And as a clerk, I saw what a mess these non-lawyers had done for these poor people who didn't speak English, who didn't have education, and who had no idea what the law was about. After being a clerk for some time, I decided to become an attorney. Whether that was a good decision or not, I'm still determining. But I can tell you, I worked all day. I went to Loyola School at night, and I studied on the weekends. That law degree and that bar card meant everything to me. I worked hard for that. I had to take a moral fitness exam. I had a background check. It was important. It meant a lot. I studied really hard for it, and I went into becoming an attorney. I started at age 38. I was not young. It was a big deal for me. I slept on my parents' couch and sold my house so I could pay to be an attorney. I want to know what these non-lawyers are doing. What skills do they have? What vetting do they have? Will they have? I don't see that the non-lawyers that I see now, I don't see that they have any experience, any dedication. They don't take an oath. So what is their obligation to their clients? There is no, I don't see that there would be policing of any sort, any regulation, and that's a concern to me. I worked for almost a decade with the top firms, 2 top firms in Los Angeles, to get the experience to go out on my own. I decided that I wanted to help the little cases. That's what I wanted to do. There were people that came to me that had small cases that no one else would take. And I said, this is what I want to do. I'm not in this anymore for the money. I want flexibility, and I want to really make a difference to the little guy. And I worry when I hear JJ come up here as a new attorney, what is her career going to be like? I don't have much more in my career before I retire, thank God. But what are new attorneys going to do when they're faced with people, they make nothing. They're going to be faced with people competing against them that will take even less money to do a job. That's extremely concerning to me. So please think very hard about accountability, about education, about any commitment that they might have. I wholeheartedly agree with Olivier that the bar should definitely put in some sort of obligation. You know, our MCLE commitment is fairly small. I believe that every attorney has plenty of time to do pro bono work. In addition to doing pro bono work for my clients, I volunteer for the court as an MSC settlement officer. I volunteer as a pro tem judge. And all of this is the way that we can serve our community, our legal community better, and give access to people who really need our skills and education and commitment. Thank you for listening to me and everyone else today.
Thank you so much. Eli.
Good morning, ladies and gentlemen. My name is Eli Grunwald. I'm an attorney. I've been practicing for 7 years. Thank you for being here. I was a public interest lawyer in the beginning of my career. I worked for public counsel as an Equal Justice Works AmeriCorps legal fellow. All this to say I was on a grant. For a year, I worked with homeless veterans. I wanted to do public interest since I was in law school. Then I volunteered for Beth Tzedec. I volunteered with Neighborhood Legal Services. I worked for A New Way of Life in Watts, and then I burned out and started to do employment law. Let's just be honest. I appreciate your work because I think the justice gap is real. When I was in public interest, we could not serve everybody who came to us. We had to rely on pro bono lawyers. I still do pro bono, but there's only so much I can do, as some of the speakers before me mentioned, because I'm in private practice. I have hundreds of thousands in student loans. Somehow these have to be paid. Earlier this year, I did a jury trial. One of the fields identified in the report was housing. I don't have any experience with family law, but I have experience in housing. I did a jury trial for a sort of nonprofit law firm called Eviction Defense Network, pretty big here in LA. First jury trial, and it's kind of a triage model. While I was doing the trial, the managing attorney was coming in and out to handle other cases. And what I worry is I know there are people who prepare documents to help. Studies have shown, I think Gary Blasi's report has shown, that when people go without lawyers into UD court, their chances are zero. If they're represented by a lawyer, the chances go up to something like 80%. I don't think that, from personal experience and from what I've heard, I don't think the chance that a limited licensed technician will help much in UD court, in housing, because it's not the document preparation that really helps. It's the negotiating a settlement and trying the cases, and for that you need lawyers. Now, I'm a solo practitioner. I do as much pro bono as I can. I represent homeless people in traffic court. I've done other things. It's not about me, really. But what we need is boots on the grounds. Other speakers have mentioned proposals, pro bono, loan forgiveness, maybe you could make third-year law school experiential, all of that. But I'm not sure that the limited legal technician, because the name itself implies limited. There's only so much these people will be able to do. My other concern is that the task force proposes to take away the definition of unauthorized practice of law. So if you take it away, that means, as someone before me said, anybody can practice law. So if anybody can practice law, why do I need to pay state bar dues? Why do I need to do CLEs? I do employment law, that's all I know, NUDs and some other things. Can I just start doing med mal cases? Can I do patent law? Can people from out of state come in and start practicing? Can anybody go in, sovereign citizens, whoever? I know I'm being extreme, but can anybody just start practicing law? Why do we need the state bar? How will you enforce it? How will you regulate it? That's like the key. I was on the state bar website and it said UPL cease and desist notices, mortgage foreclosures, the modifications. If you take this away, what's the point of having the state bar? What are you going to do? I'm not trying to insult you. That's just my points for you. Thank you so much for your work. I appreciate you very much. Thank you.
Thank you very much. Bobby Sadian.
Good morning, ladies and gentlemen. I thank you for your service, and I thank you for the opportunity to be here to speak. I'll tell you a little bit about my background. I have a bachelor's in economics from CSUN. I was a Dean's List and board of economics at the school throughout my tenure there. I have a JD MBA from Pepperdine. I have been practicing law as an entrepreneur, as one who has started, founded, and manages one of the largest personal injury firms that actually competes cooperatively with Olivier's firm. I understand the economics of law. I am a board member of CALA, CAOC. I'm on the Dean's Advisory Board of Pepperdine Law. I'm a board member of LATLC, which is Los Angeles Trial Lawyers Charities, where we donate time, resources, and money to our community on a regular basis. And the list goes on and on. This is not about me. This is about the community, and this is our duty to our profession. This is why I'm here. I've also served as a small claims court mediator, tutored children at churches, served as a president of legal division of synagogues, and I understand the importance of access to justice. Access to justice will not be provided by a big tech company, by hedge funds. When was the last time you called Amazon or Uber and were able to speak to someone who gave you qualified, high-end, personal service? It won't happen. By allowing access to the ability to practice law to non-lawyers, what will happen is we will reduce the entry barriers into this profession, thereby reducing the value of the licensure and the certification, rendering it nominal in terms of value, and thereby any entity can apply and receive licensure or certification to practice law. Once that happens, people and entities will not be afraid to lose their license or certificate, because in reality, it'll be very easy to attain. Once that happens, the ethical rules and professional rules and the enforcement thereof and the regulatory bodies will become marginalized. Because if you don't have to spend 3 years in law school and pass the bar exam and ethics required testing and so on and so forth, then who cares? We'll just get the next entrepreneur to come in and apply and get their license to practice law, and we'll just do it again. What do we have to lose? If you didn't have a serious investment into becoming a lawyer, then what do you care? The reality of it is the licensure will become dispensable, and so will the fiduciary duties to the client and the ethics and the state bar's ability to regulate these people and these entities. And let's be real, these organizations that are funding and lobbying to be able to open the door and the floodgates to non-lawyers practicing law, they're driven by profit and greed. They're not out here to help the people. They're a wolf in sheep's clothing. What's happening is tech companies and hedge funds are not interested in making the world a better place. They're here to increase their market share and shareholder value and their stock price, and that is their only motivation. And that is directly in conflict with our motivations, which are to the people and to keeping our licenses by playing by the rules and doing good for the people. I respect and encourage the State Bar and those who are here to help to provide more service to clients and to the community. And what we need to really do is empower our legal aid services, invest in our courts, invest in our judges, invest in increasing the efficiency of the legal processes that are or should be available to those who are underserved. But it's not going to work by creating the legal wild, wild west. We'll be falling into a trap. And while I agree again with the intention, I don't think the method is going to work. Furthermore, allowing non-lawyers to enter the legal arena will lead to significant confusion by those who are entering the marketplace looking for lawyers. They will not be able to understand the differences between lawyer-owned law firms and non-lawyer-owned law firms. They won't be able to appreciate the fact that they may be potentially hiring a non-lawyer-owned law firm and all of the difficulties and the conflicts that will come along with that. And I think we need to really take a deep look at the intentions and the motivations of those who are pushing for this and think about, why are they doing this? What are they after? And if they are allowed to enter this arena, what will they ultimately do? And I think what will happen is it'll be the initiation of the Ubers and the Amazons of law firms, and they won't be out there to serve the people. They'll be out there to increase their market share, and they don't even care about profit. If you look at Uber, they're a $80 billion company that's never turned a profit. All they're after is increasing market share and thereby increasing their stock price and the valuations of their shareholders. And I don't see how companies like that are going to be serving the public. And they're not here to serve the underserved and enter areas of law where, immigration and so on and so forth. That's not what they're after. They're after big profits. They'll be coming after big injuries. They'll be looking for, serious volume in personal injury, employment law, class actions areas where they can inflate their shareholder prices and sell their companies to the next hedge fund and so on and so forth.
Thank you very much. Peter Gensler.
Good morning. My name is Peter Kunstler. I am a plaintiff's attorney. I focus my practice on legal malpractice. I'm a certified specialist in legal malpractice law. And I want to echo those speakers whom I've just heard in thanking this committee for addressing a serious problem. But I must agree that the proposal to redefine or not define at all the practice of law and the unlawful practice of law is probably a dangerous precedent. I'd like to focus, because I know that other speakers have already focused on the financial concerns and the concern that the non-lawyer practitioners will eventually dominate the market and make it into a race for profit. My concern then would be to address what I have seen in my practice as a legal malpractice plaintiff's lawyer, that many of my clients come to me and they say, well, I'm going to make a complaint to the state bar about this way this lawyer treated me. And in most cases, I would agree that the lawyer has breached his or her fiduciary duty under the circumstances that the client presents to me. That's all well and good, but the state bar, unfortunately, which receives a high volume of complaints from legitimate complaints from former clients regarding their lawyers' failure to communicate with them, failure to follow their instructions, failure to treat them with the respect and honesty that a lawyer is supposed to provide to the client. And I have to say to them, make your complaint to the state bar. I'm not going to do it for you. I haven't got the time to do that. But be sure to expect, or at least to anticipate, that the state bar won't have time or resources to address your complaint, even if it's a very serious complaint. And my concern is that if we start then allowing non-lawyers to enter into this practice, what's going to happen is that we're going to see the state bar, either the state bar disciplinary system won't address those breaches of fiduciary duty. As one of my colleagues suggested earlier, we have a duty, we have those fiduciary duties according to the rules of professional conduct, but non-lawyers, will they have those same fiduciary duties? And if they do, fine, let them become lawyers. That's the way they should enter into this profession. And if they don't, we have to have serious concern about whether or not the bar is going to be able to, or take the measures necessary to address breaches of fiduciary duty on the part of these non-lawyers, where it's already overburdened with lawyers admitted to practice in California. Thank you very much.
Thank you very much. I don't have any other names of anyone in the room.
You do.
Oh, now I do. Okay, if there's anyone else who wishes to speak, we're going to hear from Aaron Joyce in a moment, but if there's anyone else in the room who wishes to speak, if you could please give your name to Mimi Lee on that corner. Ms. Joyce.
I appreciate the opportunity to address this very important State Bar Task Force, which is considering the issue of how do we close that justice gap. And the way generally the idea of justice gap as a problem has been framed is dealing with all of the underserved communities where attorneys cannot be afforded by the principals that end up in as pro pers in family law court or trying to do their own probate and the like. So when you consider the issue of the justice gap, providing services to those underserved communities, I think lawyers can be a large part of the answer. In fact, we should be. And I understand, talking to Joanna earlier, that the issue of mandated pro bono services were rejected previously, I believe in baby steps. And just because something doesn't pass one time doesn't mean it's not part of the future answer. I'm passionate about believing that lawyers are going to be the answer for providing legal services for the underserved communities. One of the ways that this can be done is by tracking pro bono hours by attorneys. This is not a revolutionary concept like many of those that are being considered by this task force. This is simply the idea of tracking voluntary pro bono hours or low bono hours that are being provided by California lawyers. And it's something that other jurisdictions are already doing. My understanding is both Illinois and Maryland track pro bono hours. And if you're someone like me that counts points on Weight Watchers, maybe not so effectively, I can tell you, when you're tracking something, you certainly value it more. You have to make those hard decisions, right? So I think just starting to track pro bono hours might be a step in the answer, would definitely be a legitimate step toward the direction of providing more services for the underserved communities. Now, I'm here on behalf of the LA County Bar Association, which took a position through the Board of Trustees and several of the sections of the LA County Bar, including the small firm section, which had a very strong response that our executive committee put together. This is the opposition to most of the proposals of the task force that are in the ATIL's proposal are not mere protectionism. What they're really based on is a strong desire to ensure quality legal services for the poor in this state. Now, I know Tammy addressed the first part of those proposals, but let me take a look at the last part of the proposals. And I think I can really address those with some competence, having been a state bar prosecutor for almost 19 years. I have seen firsthand the kind of damage that is done to California consumers when you allow non-attorneys to share fees with attorneys, to have ownership interest, albeit obviously illegal, in law firms. And because what ends up happening, and why do we have the rules of professional conduct, 5.4, which restricts the ability for non-attorneys to have a financial interest in law firms and in particular cases? It's to ensure that independent judgment of the attorneys, because that attorney has the duty of loyalty and the duty of competence and the duty to provide quality legal services to those clients. When you put a third party non-attorney in the mix, what you're doing is you're putting their financial motive first. And it's inevitable. Those cases that I used to prosecute involving UPL, those were mostly disbarment cases. And when a non-attorney's running the law firm, you almost always, sooner or later, are going to have problems with the trust account and the monies are going to be diverted away from the clients. What ends up happening in those basic CAPRA cases, which I can cite many of them for you, reported cases in those that are just going to be on the State Bar website as now disbarred lawyers, you have many, many clients missing their funds. You have attorneys that are facing serious prosecution, and you have non-attorneys that have moved on, having taken all that money. So I was really concerned when I saw the two different proposals for 5.4 changes. There's no opposition that I could see to the first part of the change proposed for 5.4, which is to allow nonprofits to more readily share fees, not just court-ordered fees. That would immediately provide access to justice for those people that I consider in the justice gap, meaning the people that seek legal aid help or neighborhood legal services help. You need to let those nonprofits more readily share fees. That's not objectionable. But the rest of the proposals to 5.4 changes are really serious. Let's take the most dramatic first. The idea of just on client consent, you can allow a non-attorney to share fees with an attorney. That's going to be just like all the contracts you have when you go into Kaiser or any of your medical providers now, where you're basically signing away a lot of your rights. The clients aren't going to know what they're doing. And what you're going to do is have wholesale fee sharing with non-attorneys. The whole profit motive and the whole purpose behind the rules of professional conduct are to ensure client concern, not profit motive for third parties or even the attorneys. So I really think if there's any differences in 5.4 that are going to be considered, the LA County Bar, and I don't think most people in general, would be opposed to the first proposal. And if there is an idea that in order to incentivize innovation, that you need to have some kind of profit motive for non-attorneys, then I would hope that you would consider the least dangerous proposal, which is allowing the 5.4 change where non-attorneys can have some interest so long as it doesn't affect the decision-making of the attorneys so that it wouldn't change the majority ownership of the firms. Now, give me a moment on 5.7. It's really hard for me to understand why there was even a proposal to adopt the ABA 5.7 when we already have case law in California which establishes when an attorney is going to be responsible for complying with the rules of professional conduct when they are providing non-legal services. So the proposal as it is not going to help California consumers. It's going to hurt California consumers and limit liability of attorneys. That's really not something that this task force should be considering. And let's turn now just to the advertising
Ms.
proposals.
Joyce, I apologize. You might not have been here when we were setting the ground rules, but you're limited to 5 minutes and you've already gone a number of minutes over that.
Oh, I am so sorry.
No,
but
that's okay. If you can just sort of start wrapping it up.
I'll wrap it up.
Thank you.
While I don't think that the two changes to the advertising rules, basically to allow texts and emails to go out as, right now, which are being prohibited by solicitations, as solicitations to be changed, those were rejected in the model rules, or when the rules were just changed in the revision just maybe 2 years ago, in the last 2 years. But one thing I can say for sure, those changes aren't going to close that justice gap. They're not going to get more attorney services for the poor who are at legal aid. So I don't think they have anything to do with what this task force is charged with doing. So I would hope you would reject those as well. And I really appreciate the extra time. I wish I had my clock going. And thank you very much.
Thank you very much. Appreciate it. Okay, I have no other names of folks in the room. Let me ask if there's anyone on the telephone who wishes to give public comment. Okay, hearing none, let's move on with the agenda. Thank you all again very much for being here, and we appreciate your comments. So the next item on the agenda is a chair's report, and all that I really wanted to do was basically turn the floor over to Leah Wilson and anyone else who wants to talk about the 2019 Justice Gap Study. It was in your materials. Hopefully you had a chance to look at it. There's a handy-dandy executive summary. And basically what you will see, if you have not had a chance to look at it, I would encourage you to do so. You'll find that this Justice Gap Study really confirms a lot of the things that we've been hearing from folks throughout our work on this effort. But it was quite a project. 4,000 people were interviewed, or almost 4,000 people interviewed, and with a particular focus on folks who are in households where they're at 125% of poverty level, and reading the things in that report really, like I said, are the things that we're hearing, that these are folks who don't understand that they have legal problems, and if they figure out that they have a legal problem, they don't know where to go, or they don't have the money to get a lawyer. So I commend it to your review. Leah, I'm going to turn it over to you.
Sure. And just as a bit of context for the 2019 California specific study, it really follows and mirrors a study conducted in 2017 by the Federal Legal Services Corporation. And that study was conducted by the National Opinion Research Center out of the University of Chicago. And the board made a very intentional decision in advancing a 2019 California-specific study to mirror the methodology of the 2017 study in most ways, including using the National Opinion Research Center out of the University of Chicago to do the study. We thought it would be very important to be able to directly compare California results to national ones. And I do hope that we are the first of many states that will undertake such a comparative analysis. But there are a couple of important distinctions, or I would call it supplemental components of the California study that I want to call out. One, the federal study was limited to those at 125% of poverty or below. And the reason for that is the federal dollars that are flowing to legal services, as well as importantly, the state funds that are distributed, the IOLTA and equal access funds that are distributed to legal services organizations here, those are limited to clients at 125% of poverty or below. The California study included a very large sample, as Justice Edmond indicated, of 125% of poverty and below households. About 2,500 of the 4,000 folks surveyed were at that income level or below. However, an intentional decision to survey folks all the way up the income ladder because we really wanted to see how far, in fact, does the justice gap go up the income ladder. There was some speculation that it's not limited to those at 125% of poverty or below. So that's one very important distinction. Another is that we specifically included a fairly large sample of Spanish-speaking households. That was not done in the national study. So those are some important distinctions, ones that we wanted to take into account. I think a third also, we made sure to include a statistically significant sample of rural households. So there were some issues that we wanted to make sure we could address in the California study that were not called out in the national one. But I will just give you some preliminary findings, or the findings from the NORC report, and then I'm going to tell you a little bit about the other components of our California effort. So we have these findings. 55% of Californians at all income levels experienced at least one civil legal issue in their household. On average, this is within the last year, on average, low-income Californians had more than 4 civil legal problems per household, while those with higher incomes had on average slightly more than 2. Across all income levels, 70% of these Californians who had experienced at least one civil legal issue received no legal assistance in the past year. Even when the legal problems that they identified had a significant impact, Californians do not receive legal help. And what we found from the study is 27% of low-income Californians received some legal help, while 34% of what we would call middle-class Californians did. And I think this is a very important finding here. That 7 percentage point difference is not, I think, as significant as many of us might have predicted. And it shows that even those in the middle class are really feeling and experiencing what we would call a justice gap, or inability to access legal services. Some interesting statistics are, for those who are seeking legal assistance, and here I'm talking specifically about low-income Californians, of the about 27% that are getting help, 10% of that, they're getting that help online. And when they're going online, what they're looking to do is they're looking to find out the law and what remedies are available to them, what are their rights, and they're trying to figure out, how can I solve this problem? A smaller percentage of them are going for what we would call pure legal information, or how to complete forms, for example, and a small percentage of them going online to find a lawyer. So I think that's some pretty interesting data. They're going online to try to say, how can I solve this problem that I have? Other interesting data points. Part of the Justice Gap study also looks at our legal services or legal aid network in California, again, mirroring the national approach. A 4-week sample of our legal services providers where they recorded all of their intakes over a 4-week period. And what we found based on that survey data is our legal services network in California, at least those about 100 organizations that are funded by the State Bar, will serve or address approximately 500,000 legal problems in the state this year. But as identified by the providers themselves, that 500,000 will only constitute about 30% of the actual need that's coming to their doors. So very significant gap even in our legal services network. These are the folks qualifying at that 125% of what's available to them. And then I wanted to close this section with a little bit of information about why people don't seek legal help. because an interesting finding from this report is not just that people aren't getting legal help, but the majority of people at our income levels are not seeking legal help. And here's the top 4 reasons. Number 1, across all income levels, uncertainty about whether their problem is in fact a legal issue. They know they have a problem. They don't know that is the problem I have a legal one. Number 2, a belief that they need to deal with the problem on their own. These are actually not in priority order, so disregard my numbers. The third, a fear of pursuing a legal action. And this is very important and different from the national data. Here in California, folks report being afraid to seek legal remedies. This is especially prevalent in immigration, but also in employment law, employment areas, and the study shows that. And number 4, concern about cost. So that's why folks are not seeking lawyers. Again, across all income spectrums, these constitute the top 4 reasons why folks aren't seeing lawyers. Wanted to give a little bit of information about some of the other components of the California study. This first phase, which has been published and provided to you in your materials, is the survey that again mirrors what was done in 2017 by the Federal Legal Services Corporation. We are also including a component of the impact of law school debt on the decisions that lawyers are making regarding their careers. This is an important issue that the board wanted to address. And so there is a whole nother component of our study where we are partnering with the Legal Aid Association of California to work with law students to gather information from law students across the state. And to date, I believe we have survey responses from about 1,500 law students. We're surveying students in their first, second, and third years, asking them about the career choices that they are making, and if at any point did they believe that did they want to go into public interest, and at what point, if any, did that change and why. We're asking them about the availability of LRAP and student loan forgiveness programs, and are those making a difference in terms of their, and also asking about their interest in or willingness to locate in rural parts of the state, because we know we have a particular justice gap crisis in rural parts of California. So that data will be folded into our final report, which will be presented to the Board of Trustees by the end of the year.
Terrific. Any further comments by anybody about this Justice Gap study? Anything, Toby, Joyce? Any other comments, questions for Leah? Okay. The next item on the agenda is the staff report. Randy?
In the interest of time, I won't go over too much in the staff report. It is item A4. And as the bulk of today's meeting will be focusing on the public input received, the memorandum actually covers not just the written public comment, but also many of the other avenues taken to receive helpful public input. The one thing I do want to call out is on page 2 and 3 of the memorandum, which are the discussions of the town hall meetings with local bar associations. We held 5 of them in San Diego County with the San Diego County Bar Association, with the Los Angeles County Bar Association, a jointly hosted one in Northern California with the Bar Association of San Francisco and the Alameda County Bar Association, even more north at the Sacramento County Bar Association, and the last one we held was with the Orange County Bar Association. And I want to take a moment to express appreciation for the effort and extreme professionalism, I must say, and courtesy extended by the members of this task force who participated in person or remotely, and some of them at more than one of these events. And so Andrew Arruda, Abhijit Chavan, Tara Bird, Judge Wendy Chang, Bridget Grammy, Andrew Kucera, Joyce Raby, Toby Rothschild, Dan Rubens, Joanna Mendoza, Kevin Moore, Mark Tuft, and Joshua Walker. Thank you very much. You represented well the task force, and one of your commitments was that you would bring back to this task force the input received. And on page 2 and 3, I've done my best to capture some of the recurring points that were raised. And for the other members of the task force who are not able to attend the town hall meetings, please take a look at those things. I wouldn't say that there's anything there that isn't also in the public comment, the thousands of public comments that we have received, but do take a look at it. We did encourage any of the attendees, either the host group, members of the local bar, or persons in the audience, to submit written comment. And in fact, looking at the public comment that they did receive, that did happen in many cases. The last thing I will mention is that the consideration of the public comment has to be tentative at this time because the entire processing of the public comment is not completed. We provided information through, I think it was September 22nd, and we had about 2,800 comments, but there's more than 1,000 comments pending that have yet to be processed by staff and put into the assignments for the subcommittee members. And so we will consider public comments, the input received. We'll try to get a handle on a consensus response. But in due deference to the fact that we don't have all of the public comments in, everything will be more fully considered at our November meeting when that process will be complete. And that's all that I have.
Okay.
Oh, I do want to actually recognize Mimi Lee to give a brief mention of her preliminary analysis of some of the breakdown of the public comment in terms of the lawyer and non-lawyer incidents throughout the comments.
Okay, when we sent this out for public comment, on the form that people filled out, we didn't ask them to require them to indicate whether they were a lawyer or non-lawyer. But based on the comments that we've read and we've interpreted, like if they explicitly says, as a lawyer who's been practicing for X amount of years, or my clients in my firm, we assume that they were lawyers. Of the comments that we received, on average, because we can't take all of them and just average them, because some people commented on multiple recommendations and some just a few, but on average, and it's a pretty good indication, I guess, 20% of the respondents to the public comment for a specific recommendation on average were lawyers. 1% were non-lawyers. 15% of the comments received were lawyer organizations. 1% was non-lawyer organizations. And 63%, and this is pretty consistent, it's anywhere between 60 to about maybe 58 to about 68% for each recommendation we couldn't identify. They didn't explicitly say they were a lawyer. They didn't say they weren't a lawyer. So we're gonna try to, in the future, maybe start looking at people's information to see if we can get more accurate numbers, because 63% is quite a large chunk of the commenters that we can't identify. And just really quickly, here on the screen, you'll see, I've just broken down a couple of them just to show you that my numbers, what it looks like. So like, for example, Proposal 2.0, which was about non-lawyers will be authorized to provide limited legal services. Of the respondents, 27% were lawyers, 2% were public, 10% lawyer organizations, 1% non-lawyers, 60% unknown. And if you look, the numbers are pretty consistent between each of the proposals of the breakdown of responses that we've gotten.
Okay, Mimi, thank you very much. Any questions for Randy or Mimi at this point? All right, the next item on the agenda is the approval of an actions summary from the August 9, 2019 meeting that was included in your materials. Any discussion? Is there a motion to approve? Second? Okay, it's been moved and seconded. Mimi, do we need to take a roll call vote?
Yes, because Dan Rubens wasn't in the room when we did vote.
Okay.
And also, I believe somebody is, Marjorie will be abstaining.
Okay.
So yes, okay. Andrew Rita.
Yes.
Simon Bomey.
Yes.
Tara Bird. Yes. Judge Wendy Chang. Abhijit Sivan. Jean Clausen. Johan Drolshagen.
Yes.
Margie Estrada.
Abstain.
Lori Gonzalez.
Yes.
Bridget Grammy.
She stepped out.
Okay. Andrew Kuchera.
Yes.
Joanna Mendoza.
Yes.
Kevin Moore. Yes. Heather Morse.
Abstain.
Joyce Raby.
Yes.
Toby Rothschild.
Yes.
Alan Rodriguez.
Yes.
Dan Rubens.
Yes.
Mark Tuft. Angelina Valverde.
Okay. Thank you all very, very much. And now we're going to jump right into the rest of the meeting. Let's talk a little bit about how that's going to go. We, as you all know, are here to basically see if we can come to a consensus on some of the responses, to some of these public comments. You all know what your assignments are. We have sort of divvied up each of the recommendations. What we want to try to do is this. Each presentation will be, or each discussion of each recommendation and the comments about them will be about 10 to 15 minutes. We'd like to try to keep it that brief if we can, because we've got a lot to get through. The presenters should give, obviously, a high-level overview of what the recommendation is to remind everybody about it, and then summarize the comments that are set forth in these tables that we've gotten, particularly focusing on the recurring comments that we got to many of these proposals. The draft response that you have in your materials now is basically a combination of an initial stab at this by the staff, and which, by the way, let me just add again, what a huge amount of work this is. And Randy and Mimi and Andrew and everybody has just really been working very, very hard on this project. So what's currently there is a combination of basically an edited version of what the staff initially proposed and then what the initial presenters have, they've added their comments. So it really is just a very limited response at this point. The goal today would be to see if we can get a consensus as a task force generally in response to each of these. So each proposal is at this point pretty much an individual response. As Randy mentioned, we have a whole lot more to do, even assuming we make it through today. The overall structure of today, we're going to have these presentations and discussions of each of the proposals. We'll take a break at 12:30 for lunch and probably keep it to about a half hour. And maybe we'll break a little bit before 12:30. And then if we manage to get through everything that's on our agenda today, which would be an absolute miracle, Kevin Moore has agreed to sort of summarize for everybody the public hearing comments that we got up in San Francisco on August 10th. But the discussion today will really be focused on the thoughtful, correct comment responses to these public comments that we've seen so far. We will not be taking a vote on any of the recommendations today, because we obviously have 1,000 more comments to go through at our next meeting. So no votes today. If the individual presenters want to, at the end of their presentation, suggest maybe in their own thoughts what might be a good idea to do with respect to this particular proposal, that is, do we affirm it, do we revise it, do we dump it? All of those things, the presenters are free to give as their own individual thoughts, but we won't be spending much time talking about debating each of the recommendations today. We'll save that for November when we've had a chance to really consider all of the public comment that's out there. I'll just say as a final note, as you all went through the materials, you've undoubtedly seen that we have an awful lot here. And we, as you've heard from what Randy said, we've not even made a dent in what we have yet to do. As a result of this, we may be going to the State Bar Board of Trustees and inquiring whether they would be willing to give a little on this December deadline that we've got. I mean, the way our schedule's going, we've got a November meeting and we've got a December meeting, and our entire report is supposed to be done. It seems to me that that's a gargantuan task. And so we may be going to the Board of Trustees and suggesting that maybe being a little bit flexible about that deadline is a good idea, because we truly want, as we keep saying to the people who are giving public comments, we truly want to consider them all and get to the right answer on these things, and we don't want to be rushed to do that. So all that is just by way of background. The final thing is, Randy, as he always does, has come up with great ideas about how we ought to discuss these things. And so we've got a chart that will keep us bouncing around. Rather than going through all of the recommendations in number order, we'll just call on people by happenstance, and there is some method to the madness. And so we'll bounce around in terms of our agenda when we discuss these things. Let me ask if there are other questions that we have about the process before we get started.
I don't have a question, but I have additional recommendations, if that's okay.
Sure.
I think in addition to a deadline kind of reconsideration, I think that's going to be vital. I also think we may want to consider the doubling down on efforts to ensure that we get public commentary. I feel that the 63% that are unknown at this time, I think from at least from the work that I was going through, a lot of it did seem like legal language and referring to rules in ways that would suggest they're likely in the profession. So I think that it's going to be really important we get that public commentary, because at the end of the day, we want to ensure that the public themselves are aware of what's going on, are involved in this process. And if we rush into creating a report based off of the data we have right now, we might end up going along on a process that is flawed from the inception. So in this case, I would recommend us spend more time in the data gathering kind of period than not. I think another thing that would be really important would be to create a flyer, an easily digestible both with pictures as well as language, to describe to the public in multiple languages, ensuring as well folks with disabilities what the process is for this task force, what the recommendations mean. Continuously, I believe there's been a mismanagement of expectations as to what is going to happen and when. We hear things consistently like, that I think folks think that the recommendations have already been put into effect. It seems like the idea that these are recommendations for public commentary for us to refine hasn't really gone through, which is a failure on our part as a task force to communicate that. So I think that'll be important. And I do think having more sessions and trying to drive participation that includes members from all levels of the delivery of legal services will be important as well. So reaching out to different groups, law schools, paralegal groups, et cetera, and some that I'm not even thinking of would be important as well. I just feel like we may find ourselves in a pretty difficult situation that if we move forward with the data we have now, it isn't indicative of the overall understanding, and we will end up making recommendations, decisions that are not informed. I also think there are continuously an evolving space where the outside world continues to change, so allowing and you would be the best to know how best to communicate this to the overall group. We may want to have the ability to make edits to that report as it goes so that the data isn't just locked in and then we have to make a decision on that data. For example, just yesterday or the day before, Amazon launched legal services that I'm not sure people are aware of. That is actually changes things quite considerably based off of understanding where we stand right now and where we don't stand. So I'm not speaking to that example as we need to address that, but I do think in the lead up to even the final pressing of the send on a report or the finalization of that report, allowing for an understanding that there will be edits and a section perhaps since we've collected the data, this is what's happened. So those are just a few things that come to mind that I think will be very important, because as it stands, I think without that, I'm worried about what ends up happening.
Lord.
I'm going to echo a little bit of what Andrew said, and I think expand on a couple of more things. Just being really honest with ourselves as a task force, I have read my assignment and worked really hard on my assignment, and I have no idea what you guys have done otherwise. And so the time factor is a major concern for me, because if I'm going to have to make a decision, I'm pretty sure everybody in this room knows how I feel, where I'm going to go. But that means I don't have enough time to really evaluate some of these comments. I'm going to go back to the idea that I think it's vital to understand where that 63% is coming from. Quite frankly, the legal field is not lawyers and non-lawyers. The legal industry is made up of many, many professionals, and we often make this delineation of lawyers versus non-lawyers. And I want to make sure that we understand whether all of those other voices are being heard. because I think their experiences and their how they serve this industry are important too. So I want to go back and say, hey, I really do think we care about that 63% as task force members, or at least I do. And the time factor, I want to make sure I'm honest about giving weight to everything I'm hearing. And to do that, I would need more time. Otherwise, I have to go with my gut, and I don't know that we're going to be able to fully evaluate those.
Yes.
Just one quick question in terms of time management. Are we covering all 3 sections of each assignment in our presentations, or are we just doing the top level? All 3. Okay, thanks.
Please.
One thing I didn't mention is that I think Lauren McCurdy already sent an email with a heads up to the subcommittee officers saying that it might be a very good idea, very prudent, to hold a teleconference meeting between now and the November meeting. And so we might be working with the subcommittee leadership and the liaisons to get that off the ground right after this meeting.
Okay. Everybody ready to jump in? All right. We're going to start, just to really confuse everybody, with item C2, which is recommendation 3.1, the adoption of proposed rule 5.4 alternative 1. That is, as I understand it, Professor Moore and Alan.
Okay, proposal 3.1 involves the proposed revisions to Rule 5.4, the alternative 1. This is not the client consent model. This is the model under which the non-lawyers would have the ability to have an ownership interest in a law firm. And the law firm, its only services are going to be the provision of legal services. And any owner is also going to be required to assist. So realistically, what we're talking about is not a situation where there's going to be passive investment by non-lawyers in a law firm, but these are non-lawyers who are going to be participating in the delivery of legal services to the clients. Now, based on many of the public comments that we've received, we've begun to believe that we need to sharpen the proposal a bit, but we'll get into that in a little bit. I just want to summarize again what is going to be permitted aside from this non-lawyer ownership in the legal services organization. We would expand the ability of lawyers to share legal fees with a nonprofit organization. I'm not sure anybody objects to that. Already, there's a provision in the current rule that permits this to occur, but we try to broaden the types of nonprofit organizations with whom fees can be shared, and it wouldn't just be limited to court-awarded legal fees. The proposed draft actually relies in part on language that we took from the District of Columbia's Rule 5.4, and DC has gone a little bit further than most jurisdictions in permitting these types of fee sharing. As for the second part, which is probably more controversial, and that is what I just described, non-lawyer ownership, we're looking at that, and I'd like to address some of the issues that we... I'm sorry. Okay. All right. Fair enough. I am told that I have a nervous tick in my pen. Okay. So I'll try not to wrap my knuckles like I was doing on the 110 this morning. There was a SIG alert as I was pounding on the steering wheel. Okay. Some of the possible changes
that we actually discussed most of these in the group, the subcommittee that drafted the rule. But there could be a percentage cap on the ownership interest by non-lawyers in the firm. Requirement that non-lawyers have continuing legal education and be trained in the ethics of lawyers. One proposal that's come out is the concept of a moral character evaluation similar to what lawyers must submit to before they are going to be admitted to the bar. And finally, something that we may have to do just because of the broad interpretation that has been given to assist lawyers in providing legal services. It appears that some people view assisting lawyers in providing legal services might be assisting lawyers in finding clients, as opposed to assisting them in the actual provision of the legal services to existing clients. So we may have to tighten up and explain what is intended by the rule in terms of assistance. Now, we have proposed, and you have it in the memo that's been provided to you, responses that are still being developed to common comments that we've received from the public during the public comment period. We've also identified 5 separate comments that are not necessarily reflected in the recurring comments from the public. And some of these have been received with respect to other proposals. I think you're going to recognize them. But these are things that we thought might be worth a brief discussion today, or if you prefer to put it over and just ask us to go forward and propose a suggestion. We identified 584D, James Gorton, who raised an interesting point, and I think this is a repeated point that we've heard during the town hall sessions. They're strewn throughout the public comments that we've received, and we've heard this morning from many of the people who have commented, and that is that this isn't just a lawyer problem, it is also a court problem, and the concept that there has to be an expansion of the dispute resolution process. So this is perhaps one avenue toward achieving access to justice, but by itself, it might not be sufficient. Mr. Hart, 756C, we wanted to think it's important that we clarify precisely what the rule would permit, and that might be best done by actually revising the rule. I'm going to ask Alan to talk a little bit about Mr. Giorgio, Anton Giorgio. That was proposal or public comment 13B, who raised the issue of capital. And Alan, if you want to address that.
Happy to, thank you. So what I found interesting about this comment, well, one other recurring theme among these is the loss of or the imbalance of power, that capital may somehow corrupt an attorney in their ability to provide service, which I don't necessarily agree with. But nonetheless, the one thing in particular with this comment, and I won't read it outright, was the concept of employing attorneys and splitting their fee with them, which I think for the most part we've not kind of really thought through in a way that I think deserves attention. I think that is a real concern that we should probably think about as we get into the details of such a thing. But the basic comment is that what if you have a company, like say, I'm going to use Amazon as an example, that starts offering a legal service and they hire 20 lawyers, right, to work for them and kind of provide that service. So I chose this one as something that we need to consider because what we've been kind of talking about mostly is collaborating with allied professionals within a law firm as opposed to somebody wholesale just hiring an army of lawyers and kind of employing them. So.
Okay, thank you, Alan. And the next comment kind of follows up on that, that we're not really going forward with this concept that we are inviting passive investment in law firms. And Mr. Wad, comment 281F, seems to believe, and this was a comment that more than one people were making, that what's driving this task force is not so much the justice gap that's pretty well established and has been shown to exist, but rather it's the tech companies that are seeing that there is an opportunity for them, as several people have noted this morning and also folks noted during the town hall sessions, that they're trying to increase share valuation, stock valuation, and so forth, increase market share. Their investors are something that they are particularly interested in. But we might want to respond to that anytime that comes up and just focus on what the problem is, and that it isn't this sort of alternative view that we're really trying to satisfy tech companies, but that we're trying to solve a problem. Finally, we received a comment from a organization called the Legal Value Firm that they are attempting to franchise sort of low-cost legal services, storefront types of firms. And it was a supportive comment. But again, my impression is that the implication is they believe that this proposal would permit passive investment, would provide the capital in the law firms, which I don't think is what this proposal is all about at all. We don't want to go too far, too quickly at once. Seriously, this is what we have viewed as a modest proposal. I find it kind of interesting that a lot of people keep referring to Amazon. 20 years ago, when the multidisciplinary practice proposals came out, the fear was Sears. Now, nobody's afraid of Sears these days, but I think that, yes, the concern about Amazon, it's a very real concern. I understand the concern, but that's not what this proposal is trying to accomplish. Any questions? Comments?
Lori. I'm sorry, Joanne, I didn't see your hand.
That's okay. Lori, go first. I think I guess my question is, and I probably will need to answer this for myself, but it sounds like there is a lot of very similar comments to alternative 1 versus alternative 2, which, as the subcommittee who came up with that, I can tell you we know they're not the same. We had a lot of discussion about that. So I just wanted to confirm my sort of very quick peruse. Is that both Alan and Kevin, is that true? Is that generally true that it's a very similar response?
The way I read them, yes. Yeah.
I would agree that the response has been similar. I guess to both of the proposals, and part of it is that I think some of the same responses were submitted as to both proposals. So you didn't have to decide which one you were going to comment on. I note that Erin Joyce earlier commented, perhaps it's the least of the evils, that was not unalterably opposed to alternative 1 of 5.4. That I think that the recognition is that if you do a bit of a deep dive into it, is that it is just a modest proposal. It is not that radical. The alternative 2, however, might be viewed as, or is viewed, I think, consistently as a little bit more radical.
Joanne.
I'm struggling with our process a little bit because
so these recommendations overlap in so many ways that we're getting the same type of comments as to multiple recommendations. I'm not, I'm struggling with the best way for us to actually process this and move forward without repeating ourselves and going over the same types of comments for the same issues. It just doesn't seem particularly efficient the way we're doing this. And we certainly want to have the same response to the same type of comment, despite whether or not it's a different recommendation they're referring to. I'm struggling with the process that we're going through right now. I just wanted to share that.
I think that that's reasonable and fair, a description of sort of where we're headed. This is obviously the first recommendation we're talking about. So to the extent that we get follow-up comments that are very similar, I think we don't need to spend a lot of time talking about them, simply conclude that we will be consistent with what we said in the last one, and we don't have to discuss it again. I think it seems like where we're going on this one is we need to make sure that we clarify in the response to these comments as to this recommendation, the more limited nature and how it is intended to be much more restrictive than alternative two. And then to the extent that the comments are very repetitive with respect to the alternative two, I don't think we need to go through them again.
Yeah, oh, sorry, Kevin.
Yeah, the only thing I wanted to raise is, for example, one of the comments we wanted to bring to the attention that I think needs to be addressed is the repeated comments we've received on court resources, that it's not just a lawyer problem.
Yeah.
We raised that, we just raised it. We're not proposing what the response should be at this point, and I don't think anyone should necessarily focus on a response. What we should just be doing is identifying those responses that during the interim between meetings is where we're going to take the time to draft a response, circulate it, and then come up with something that we can bring back to the meeting and propose at some point to vote on that this is an appropriate response.
So I take it's your recommendation, Kevin, that we, and Alan, that we address between now and the next meeting, we come up with responses to each of these individual comments that appear to be slightly different from the recurring comments.
Yeah, I think that's true, and also perhaps to address some of the comments that have come in that we might be able to address by revising the proposal, because then we can have a simple response. We have revised the proposal in accordance with your comment.
Yeah, I want to just add that what I found, there are some copy and paste comments that we're probably going to find in all the recommendations. And what I'm reading in a lot of these, and certainly when I talk about recommendation 3.0, is that these are really education opportunities. I think the summary perception of what we've proposed here is not consistent with the intent behind the committee services. So I think wherever our responses end up for all the different recommendations, they should come from a point of educating the people who have contributed, as opposed to kind of critically responding to and disagreeing with their positions on the matters.
So do I also understand you two to be saying that between now and the next meeting, you'll also take a stab at redrafting or revising the recommendation to the extent you think that's a good idea?
We might do that, but that's really going to be, I think, up to the subcommittee that's dealing with it and how much time we have, because what I heard is that there's 1,000 more comments that we haven't seen yet.
One of the things I'm thinking of is it seems to me that the same response, and this has been echoed multiple times here, will work for a variety of different comments. And so that if each subcommittee works on their own answers, then it actually would be their own answers to the same objections. And Alan brought up a great point that in many cases, some of them are actually copy and pasted in multiple areas. So we may want to almost say, these are the 16, 17, 18, whatever that number is, of the universal ones that seem to be themes that pop up across. And then for each subcommittee, these are the ones that are unique to that subcommittee's responses that aren't present in any of the other ones. So right now I'm sensing like, and when I speak to like we're all going to speak to very similar themes, so that might be a way we want to organize it.
Because we didn't actually make these proposals, so it's like we're defending, or kind of feel like we're defending ideas that we didn't actually recommend. So it almost be helpful to figure out how we are going to, what is our actual recommendation going to be? Because we might look at some of these responses and go, yeah, we agree. So yeah, you're right, and that's been incorporated within our proposal. This is why we propose. I mean, that's to me is what our proposal will reflect. These are our public comments. And this is our proposal, and this is why we believe this will work, and these are the reasons we, we went this way and not this way in response to what people said. Because otherwise, it's very challenging to absorb these and turn them into a work product. That's my thought.
Another suggestion would be to actually use a third-party group that we might have to create as part of this. I'm sure resources-wise, it might be tough to find that, but even actually participation of some of the groups that provided some of the commentary to it, if they would also like to kind of fund initiatives. I'm not sure what that would look like, but have cross-collaboration between those who offered their the comments themselves to also work together in a collaborative way. I'm not sure what that would look like, but just something I'd brought up.
Yeah, I think I want to talk about the idea that I think many, if not all of the task force members have spent a substantial amount of time reading the comments. So earlier I kind of joked about, I don't know what everybody else is responding to, but I actually do. I've spent that time reading those comments. And in our effort to respond individually to each comment, we may be creating such a volume of work that we actually lose the ability for our subcommittees who put these proposals together to actually create one response that incorporates both education we've received from the comments, which I think is important to all of us, and education we can provide back out as to why we've chosen these on the subcommittees. And so I think we're all kind of saying the same thing of, hey, this table started out as a really great idea, but the volume of dealing with putting it all together in a per comment may actually weaken or lessen the idea that we've actually read all of these comments and we want to respond to them. So I don't think we have to go individual, and maybe instead should have, I love the idea of a third party putting them together. It also gives some transparency to this group because we all have very specific ideas and biases, whether we know it or not. And so I really would love to have something that says, read all the comments, subcommittees and task force members, but now here's a synopsis from someone outside of this task force. And then we present of the differing types of comments, and then we present our response as a whole. So I'm just kind of thinking through that.
Randy, you want to comment?
Open to the idea of outside assistance. That's welcome. I'm not exactly sure how we could manage it within our current sort of system. And the concept of individual responses is basically a carry forward of direction my office has received from past work with regulatory stakeholders in terms of you put something out for comment, there's going to be interest in knowing what the deliberative body's view is of the comment. And it doesn't mean you have to customize a response to every single one of the hundreds of comments we received, which is why we're going through the recurring points approach. Staff will carry the heavy laboring oar of accounting for repetitive comments across all of the different 16 proposals, and we'll, with your good work, be able to populate them for your consideration. Now, all of this has to be subject to what we talk about in November, because like Tara said, that's when we sort of dig into the actual recommendations. And the same way we handled on the Rules Revision Commission, if we had a general idea of what the response was to a particular comment, but then when we actually voted on the final rule, we did some adjustment. We added a new comment to a rule that was actually in response to one of the public comments received, then we'd go back and we'd conform the public comment response to say, yeah, we generally felt that, you were perhaps overthinking what we were actually proposing, but to the extent you said that, we needed to cross-reference the statute, we did. We changed the proposal in light of it. And so that type of after-the-fact conforming, once the recommendations are fully vetted, is something that we have to do as well. All of this sort of speaks to what Justice Edmonds said about maybe a little bit more time would make a big difference.
Yeah, I mean, it sounds like what we need to do is, we need to know what our response is to these, but then have time to make the revisions, which is the really important part, to the extent that that things are going to be revised. And if we have literally one meeting to do that, it's kind of impossible. So I'm just going to assume we're going to somehow get more time. And why don't we continue with this process in terms of trying to figure out how we're going to respond? We'll sort of leave that to this today, particularly because we've got so many more comments to respond to at the next meeting. So Kevin and Alan, to wrap this up, anything, well, let me just open it to anybody. Does anybody want to further comment on any of these possible responses that we have to this particular recommendation?
Yeah.
Johan.
Is it possible to land this plane and pick one? Because 5.4 is at the core of this. I'll promise you that the subcommittee split right down the middle on the two alternatives, and I think probably the task forces as well. But if we can take one of them off the table, we get a better chance at moving forward. Because I promise you, I will disagree with everything Kevin just said. Respectfully, I like the guy, I really do. We're gonna take a trip across the country in a Volkswagen Bug when this is over. But
we may make it to the Sierra foothills.
So I'm just suggesting that there's a very clear delineation between the two, and if we're spending the time on both, and if we're modifying both, but there's a fundamental difference that we have to choose.
Mark.
Can I ask just a fundamental question?
Well, you can ask.
I mean, are we focused on the Access to Justice survey that we just received? I mean, is that what we're here for? Yeah, are we actually thinking of proposals how to narrow the justice gap? Because if we are, then there's really, we've overshot the runway on 5.4. If we're really serious about finding ways to get more information to consumers, to get them answers to their legal questions, provide them with solid quality legal services, what are we talking about? You're not going to change 5.4 for all America. That's why the big law firm comment I thought was so important. You better wake up and realize what the implications are going to be if you pass that rule for all purposes. Is that what we're here for? Because we are, then I'm in the wrong meeting. I thought we were here to get access to justice for the 70% of Americans or citizens in this state that don't have access through information and through better ways of servicing those people. We could debate 5.4 all day. There may be sandbox solutions, which I'm very much in favor of, where people come in with proposals on how to service those consumers that would lessen the restrictions in 5.4. I'll listen to that. But to say we're going to have 5.4 change for everyone is a mission that cannot be solved in this room, I'm sorry to say.
I'm going to start by respectfully disagreeing that we can't solve that, or that 5.4, either option is overshooting anything. When the status quo means 70% of Californians aren't getting what they need, we need a drastic change. So we have to be prepared to at least acknowledge our current system with our current protections. I do want to kind of point out that 2 states have already either removed completely or drastically change 5.4 who are doing the exact same work we're doing. So we are not necessarily talking about something no one's willing to even consider, and that the other professionals and experts who are looking to do the same thing we are doing right now have considered that this is worthy of trying. So I just want to throw that out there. Obviously, there are very differing views about 5.4, and we all need to listen to, I think we're all very dedicated to understanding why those feelings are so strong. But I don't want us to start this out with, we're overshooting when we are failing the majority of our consumers in California and everywhere else. This is not just California. So I'm just going to kind of throw that out there.
Simon.
Madam Chair, I just didn't want Johan, my colleague's point, to get lost in the conversation, and I was wondering if the chair would entertain a motion for the committee to at least accept a motion to discuss voting if we should pick one alternative. I think 5.4, as my colleague Gloria said, it is important, but I think we can start to narrow and have a more serious conversation if we do pick one of the alternatives. And so I'd like to propose the motion that as a committee we pick one of those alternatives to move forward.
To respond to that, I don't know if we're at the point where we can, I mean, certainly for responding to public comments, is that what we're talking about? Because we can pick one and just the responses to the public comments, I think, are generally the same. But as far as whether we are going to make a formal proposal for 5.4 or not, has a lot of overlap with, the discussion about non-lawyer entities in general. So I don't think we can move forward and say, well, we don't even know whether we're going to pick any of them.
Do you want to respond to that? I agree with you, but I think in terms of narrowing the conversation, and also in the spirit of saying that we have been educated by the public responses and that we've picked one that we may or may not vote on, but one as a subcommittee we want to explore deeper and see if it is possible for us to accept it or maybe not. I think picking one of them moving forward in terms of the process would make things much easier.
Let me just comment. I agree with you. It'd be wonderful to be able to focus on one and not have to spend our time on two. The difficulty I personally have with that is that we're in the middle of this process. We've opened it up for public comment, and we haven't made a dent in looking at those public comments. And so I have no idea how today we could really make an informed decision when we get 1,000 comments that we haven't even glanced at yet. I want everybody to understand that we took their comments seriously, we considered them, and I agree with Tara. I don't know in the end what we're going to do. If we're going to do anything at all with 5.4, or whether it's 5.41, 5.4 alternative 2, whatever it is, I don't feel at this point in time that we should sort of cut short the consideration of the public comments in order to do that. Now, having said that, you made a motion. If there's a second, we can open it up for discussion. I'll just tell you my own personal reservations with deciding that issue now. As sympathetic as I am with people spending time on something that might turn out not to be supported, but I certainly understand that, but I have those reservations.
Sure. I did make the motion, but just to comment, there is, and to Andrew's earlier point, I could not agree more that I think this is a period where we have to collect even more data and make data-driven decisions throughout the comments. Where is the research, where is the data? And I think as a committee that will only strengthen us. And I forget who said this, but I think Alan did, to provide a real educational opportunity for people. I think this is a real learning for us and for the public as well. But I would just, I don't know if I necessarily agree with Andrew that we need to extend the deadline for this. I think there's so much data, there's so much information that we could be talking about this until 2022. And we don't, because the urgency of addressing access to justice is so critical that I would just encourage the chair and the staff to think about ways that we can try to meet our deadlines.
And does that mean you're withdrawing your motion?
If there's a second, then I'll keep it.
I'm actually not going to second it, and I'm going to shock my two friends over here for a second and just actually suggest that I would actually vote against removing one right now. And I'm sharing that because I think the subcommittee put a lot of effort into the two alternatives, and we had some good reasons for voting those. And I'm very interested in hearing the public comment on both as we continue that process. So I know it's a lot of work, and I feel like the comments are very similar, which is why the efficiency experts want to just mush it all together. But I also recognize they're two very drastic proposals, and I am interested in hearing and reading those as we draft our responses.
I also think that one thing that we want to be careful about is as we continue to open up for additional comments, I've seen this happen in kind of various organizations I've been involved in the past. You might get an influx of comments to prolong the overall period of time because that will kind of complicate things. So while I can respect the idea of more time, we could be speaking about these issues for the next 10 years. I do think that there's going to be I'm not asking for that much time. I think we just need a little bit more time than what has been planned, especially considering we want to make the right decisions here. So,
you want to vote?
No, it's fine to withdraw the motion.
No, that's good.
And maybe I could have been more clear in the motion. I don't think we should certainly disregard any comment, and that's not the intention of
No,
this. I think
I didn't
for the
take it that way.
I think for the sake of moving forward expeditiously, and I agree with Andrew, to make the right decision, we need to have all comments. I think eventually, hopefully, I can encourage my colleagues to think about one alternative over another, obviously, for a final recommendation.
Okay. Bridget, sorry.
I'll be quick. One thing I'm struggling with here is that outside of the 5.4 subcommittee, we have a whole other subcommittee that's been dealing with entity regulation. And this is where I'm struggling with this overlap as we have been the whole time. I'm hesitant to try to narrow it. I mean, I know we're not having this as a motion, but even having this discussion is difficult before we've had Andrew present on the entity regulation proposal. So I wanted to throw that in. And the other quick thing, just as an observer of public comment in general and regulatory processes, it seems to me that the comments we've received so far and the point of the public comment so far has been very different than the typical comment on a rule that we've developed. And so I do just wonder, something for staff to consider, whether this is the type of thing that we have to respond comment by comment on, because really we're trying to use this to inform what our recommendation is going to be, as opposed to just having people comment on a baked recommendation. So I just wanted to throw that out there.
It's a very difficult process because of the shortened timeline that we had. We've got these 40,000-foot broad ideas. I won't even call them recommendations because there have been no votes. And I think that's part of what has driven the public comment, that people don't really know what this is going to look like in the end. I mean, there have been lots of comments about concerns of no regulation in this particular area, and I think everybody around the table anticipates that there would be regulation. And so it's just been a difficult process.
I mean, not to open Pandora's box, but just food for thought. I mean, is it possible that we can have a second comment period once we've actually refined our recommendations? Because I do think a lot of the comments we're getting is just because we haven't been able to say exactly what this would look like. And so anyway, I just throw that out there.
Toby has been dying to speak, and then unfortunately we're going to have to take a break. We're going to break for lunch from 12:30 to 1, but go ahead.
Final comment, I guess. I wanted to agree with Lori that things aren't working. It's been, for as long as we know, and from my experience, clearly things aren't working in terms of access. But agreeing with Mark, I think we need we have pros and cons on each of these, but I don't know that we ever said, how will this particular proposal increase access to justice to low and middle class people, middle income people? I don't think we've ever focused on that issue in our responses, and I think that's where we really need to look.
Okay, let's take a break.
So Justice Edmond is engaged in a conference call and asked that we go ahead and start without her. So we will move on. And the next one on the list that we're going to look at is D2, recommendation 2.0, with Bridget and Mark.
Okay, so I think what would be, I'm going to propose like what I think would be helpful for this discussion, which is just about allowing non-lawyers to practice, which seems to be the bulk of what kind of comments that we've been hearing, at least today. And I have gone through my little notebook full of comments here as well. That I thought it would be helpful to just bring up some common themes that we were hearing and have a discussion, I mean, at least kind of questions or hear people's thoughts about these bigger picture issues before we drill down into specifics as to how we should be responding to them. I just think it would be helpful to have a forum for some of these conversations. So I think what I'll do is just highlight generally kind of bullet point off some of the bigger issues, and then perhaps, Toby, if you're okay with it, we can just open it up for discussion. And then Mark, you can just chime in if I'm missing anything. Does that sound reasonable? Okay, so just kind of general themes that I heard. The first, something that concerned me, and as far as comments that we've been hearing, both in the town halls and reading the comments, is that I think the public were not reading the full recommendation as far as what we meant by appropriately regulated. I think there seems to be a perception that we're recommending a deregulation of the legal services market, and at least as far as my subcommittee was concerned, we were more looking at opening up the regulated market. So I think there's a real difference there. And to me, we were never intending, and we need to make sure that we're clear in this recommendation going forward, that, for instance, some of the comments we've heard today, like disbarred attorneys would be able to come on, or, people that are, we heard some comments, I don't know, about particularly bad people in society that we would just open up and allow to practice. So the recommendation definitely contemplates you'd have to meet eligibility requirements, there would be a measurement of competence, and a measure of accountability with respect to the regulation of non-lawyers in some way, shape, or form. It would not just be, doesn't matter if you have a law degree or not, just feel free to practice, which I think is how some people were interpreting the recommendation. So I just wanted to get that out there. There were a lot of comments from people saying, oh, I worked so hard to go to law school and now you've completely devalued my degree. I really don't think that was not what the recommendation is, and so we need to just somehow clarify for people that issue. But with respect, so setting all those kind of bigger, concerns aside that I heard, some that I do think are warrant some further discussion from us. I've heard from a lot of people concern about having a two-tiered legal system. So if we do have a non-lawyer, and I know some people don't like the term non-lawyer, which I think it is challenging, but anyway, that is what we're using right now. If there are people, they're afraid that this will impact the most vulnerable in our society by allowing, people that cannot afford lawyers will have these substandard non-lawyers, and then people that can afford it will have lawyers, and that will just perpetuate this justice gap in a different way. So that's a concern that I've heard. There were many examples that I do think we should look into more seriously, from people saying, I work on the ground. We've heard from a lot of legal services people, particularly, that come to mind, even when we were in Orange County, at least one district attorney who do work in the UPL cases and do have real life experience working with either undoing damage that a non-lawyer did, or have serious concerns about clients and because of particular individuals. So I just want to make sure that we're understanding what those are and hearing people's experiences with that in a way that allow us to think more carefully about, if we are going to open it up, what would an actual regulatory framework look like that can make sure people are not going to be harmed in the process. And then those were kind of specific to practice areas. So one is immigration law, came up a lot. I'm sure you all heard this in your various things. And this is something I think we need to give a lot of thought to. I mean, there are some real serious consequences if this goes wrong. People can be deported. It's irreparable, and the stakes are really high. So I just think we have to be very careful about this particular issue and be very thoughtful about what we're doing in the context of immigration law. But setting that aside, other practice areas that came up a lot in the comments were estate planning. So people being concerned about trust mills, family law, domestic violence, and elder abuse, and then also bankruptcy. So we did hear from several bankruptcy attorneys that had experienced issues with document preparers that are certified but had done something wrong. And so anyway, those are some comments. And then the other just kind of more general comment was a concern about recourse. What is going to, and we heard some of those today as well. What would happen? How are people going to be able to make sure that these non-lawyers are held accountable? And I think that's doable through a regulatory framework, but I think the biggest concern the public is having so far is not understanding what we're thinking about or how that might look. So I think just generally more clarity about what the regulatory framework would actually look like, I think would be helpful to a lot of the comments that we received. And anything else you want to add, Mark? Those are just some of the bigger picture issues.
I thought you covered it very well. I had just a few additional observations. I'm not sure the commenters appreciate the fact that 2.0, like many of the other recommendations, are really part of a menu approach to the problem. And of course, I think we could spend some time here talking about what we think the problem is, but let's assume we all agree what the problem is. We did come out with alternative proposals, and I'm not sure the commenters picked it up as alternatives, because when you get to the comments on 2.0, it really bleeds over into entity regulation and sharing of fees and combining lawyer and non-lawyer services, which really belonged in some other proposal. To me, and I guess my point is I think we need better clarity in what we mean by this proposal. When we wrote it, we're not talking about entity regulation at all. We're talking about non-lawyers being authorized to provide specific or specified legal advice and services. It didn't say legal services, it just said specified advice and services, which begs the question, what are they? And specified in what way and in what specialty, what field? That was an open issue. And then it said as an exemption to UPL. So it's about modifying the UPL statute or rules in some way that would permit more services. So for those of us who voted in favor of it, such as myself, I thought it was a way of trying to respond to Professor Sandiford's wonderful presentation about not getting sufficient detailed information to a consumer about their specific legal problem and what the solutions are for their problem, and then how much further would we allow this person to go. That's what I thought was in 2.0. The second thing I wanted to mention, and I think the comments are not focused on that. They're all over the lot. The second thing that I noticed in the comments was, and I have to say, I thought the California women, the California women lawyers comment, which is also picked up by the Fresno County Bar, made a valid point that the law is so profoundly complex that even licensing someone to provide advice or services in, let's say, family law or domestic violence or housing is going to open up the possibility that there are other complex overarching issues that are not going to be included in that service, which in our parlance, at least from my familiarity, we're dealing with unbundled legal services. We're dealing with a defined scope of services that it's not the full panoply of legal advice or legal services. If the consumer understands that and is willing to accept that, then I think the quality issue is not so difficult for me. If I'm limited in a specific field domestic violence, for example, which I think one of the comments was that's a really difficult area and not everyone should be allowed to practice it. But let's just say you do have a licensing for a non-lawyer to give some more detailed help and assistance in that very critical area of need. The consumer has to understand, look, under a famous case, Nichols versus Keller, I'm going to tell you that there's a lot of other overarching things that you really, really need to know about. I'm not licensed to give you that advice. I'm going to have to refer you to somebody else. I think we should address that. We don't address those. So I think clarity is important. But this recommendation does not deal with entity regulation. It deals with the specific non-lawyer being licensed to give specific services. Somehow in the comments, and I think some of the recurring themes sort of bleeds over into other issues. I don't think that's right. I think we should be much more focused on what this proposal is suggesting and leave for another day the other issues.
I did, as you were talking, I was reminded about another common theme, which was this disclosure issue. And I think we also heard this today. People are going to be confused. Consumers are going to be confused. They're not going to know if they're hearing from a lawyer or from a non-lawyer. They're not going to understand the services that they're getting. And so I do think, as far as clarity goes, it's another issue. But I mean, Lori, I was thinking about comments that you've made throughout as I was reading these, as far as the quality issues. We heard a lot about, the subpar quality of non-lawyers versus lawyers. And also with respect to the disclosure, I was really mindful of your comments when you were saying, let me make that decision for myself. I don't need you to tell me for my protection that I can either pay $400 an hour for an attorney or nothing to protect me. I think I think we can be mindful about appropriate disclosures, about limiting services, and making sure that it is transparent and it is clear to consumers what they're getting, and allowing them to make a decision for themselves. I mean, we started to use this analogy, but I do think it's important from the medical profession if you're thinking about nurse practitioners. There were several comments that said, do we let non-doctors practice medicine? And the answer is yes, we do. I mean, a lot of people, they assume that we don't. And then one of the comments did say something like, would we allow a nurse to perform surgery? Well, maybe not, but there's a big scope when you're talking about legal services. So yes, Tara.
Along the same lines of what both of you said, which was sort of that this is going to be more narrowly defined than I think the way people are receiving it. Also, the point that we haven't defined UPL, and so what is a legal service, and that it sounds like I don't know if we're going to define UPL or maybe define what UPL is not, which is a proposal. We can get into that later, but I think mentioning that look, there's not a clear line as to what is or is not the practice of law, but we want to allow more room that may encroach the practice of law, like providing information. I always think of title issues, how to take title in your home. Do you consider that practice of law? Because that might be, but it might just be giving information. And some of those issues, I think that's relevant here.
I think that is one of the easiest issues for us to attack. Let me tell you why. There's the unauthorized practice of law, and then there's the authorized practice of law. And we have a rule of court, 9.40, that has a whole series of activities that are authorized practice of law in California. So rather than get into, is this a legal service or is this not a legal service? If a banker can do it, why can't I? That kind of stuff. That's not the right question. The right question, are we willing to carve out as another exception under the California Rules of Court or by legislature if you choose? I prefer the California Rules of Court. An exemption or modification that allows a certain activity. We do it for law students. We do it for foreign consultants. Why can't we do it for a discrete class of non-lawyers to provide a needed service in a specified area of practice? It kind of fits in with this whole sandbox approach, I think. If somebody comes to me and says, look, I've got the greatest idea in the world to get consumers on board with this area of the law. If we need to create a rule of court, on a trial basis or a sandbox basis, I don't think you have to get into a definition of what's the practice of law. I think you've done it with the exemption.
I think I want to address kind of two discrete issues. I do want to talk about the notario and immigration issue, because that I think is an overreaching theme in many of these proposals. I'm going to share that I have been a victim of a notario. I have worked with lawyers who worked with attorney generals in Tennessee to fight notarios, and I remain very passionate personally and professionally about immigration law. And so I share all of that to say it is not an issue I take lightly. I will also share that I don't need a law license to practice immigration law before the Board of Immigration Appeals. And that is something that is not always well known as well. So the idea that immigration law is a place where only lawyers can practice is actually not true today under our current regulations. And nothing here that happens in California changes the rules with the Board of Immigration Appeals. So we have already, in a super complex type of law as a country, in a place where there is rampant fraud, allowed people who do not have a law license to practice law. And I just kind of want to be real about our current state when we're going through these proposals. I also want to think about this idea of sophistication of our clients. I don't, just like Bridget has kind of pointed out, this idea that we're confused by who's practicing law and who's a lawyer and who's not, that's what's happening. I challenge anyone who believes that to the utmost to think about how many times they've walked into any medical facility and been confused by who was the doctor and who was the medical professional assisting the doctor in some way, or perhaps not assisting the doctor. I am never confused by a chiropractor versus a physical therapist versus a nurse practitioner versus a doctor. And so we have the ability to discern that as a public, and we have the ability in our industry to make sure that that doesn't happen. I think that this fear that that will happen is not based on an honest evaluation of who consumers are already choosing in other industries just like ours. So I just kind of want to throw that out as we work through this. Those points are very important. They're very valid. Those fears are real, but they're not actually based on, if we look at the common sense approach of what is happening. And I think my final point is every single one of us here knows someone who is not a lawyer who's practiced law. You know how I know that? Because 70% of your consumers don't have a lawyer assisting them. So what we're saying is, I'm not going to allow a skilled professional to come in to this industry because of all the harm they could do, but I am going to allow the unsophisticated person, I think, who can't develop a tiered system. I don't want them to have a tiered system. We have a tiered system already. We have a tiered system. So we got to stop pretending like we're going to create one. We're trying to level the playing field. So I just kind of want to remind us of those realities, because we're talking very abstractly, but there's some real world things that are already happening that sort of negate those ideas, I think.
I just have one more comment that I just noticed. A number of the responders spoke of the Triple LT program from Washington, state of Washington, which falls, I guess, in large part within this proposal. And they speak of it mostly critically. Some think it's fine, but I think everyone agrees it's not successful. And that brings to mind an observation on my part that, and I've talked to the people in Washington State that promulgated the triple LTs, and they're very glad they did it because they thought it was a very good first step. Of course, it's going to have, consequences, and they've learned from it, and so they're going to continue on with that program, and I think we should too. I don't think we should dismiss the triple LT concept just because it got so regulated that hardly anyone signed up for it. So I think we should still keep it on the table, is number one. Number two, this is my observation. I remember going far back when the LRS regulations came into being with regulated lawyer referral services, and how stringent they became, and how frankly fewer LRSs are under the umbrella of the minimum standards than are outside the umbrella. I mean, right now, they talk about what's going on today. There's a lot of outfits out there that ought to be under the minimum standards of LRSs. They're not, because they're too onerous. They don't want to comply with them. They're finding ways around them. And that's going to happen as we come up with appropriate regulation of the individual non-lawyer. We have to keep that in mind. And so the LLT experience is valuable and is a good baseline to work from. So I think we should keep it, it should be on the table, and we should improve on it, but not dismiss it as one option in this multi-option task.
I'm aware that we probably want to move on, but this will have universal applicability. One of the things that I think we haven't put forward in the responses that I think could be is one of the reasons why I see the need to have kind of the varied levels. We heard nurse practitioners, et cetera, is that with various certificate programs and various kind of levels, that also will go towards helping with issues around disability, accessibility, also in multiple languages. I grew up in a community and actually served a community with my law firm in different languages with individuals who would come in. I do speak multiple languages and the language of the community, but oftentimes that's not the case. But oftentimes in the delivery of medical services, nurses and other individuals who aren't specialized with the full kind of scope of what they can do help in that process, explaining things, et cetera. And that's lacking from some of our responses. And I think that is an additional benefit that would go a long way from an access to justice standpoint. It's the language, but also if you have multi-layers with certificates, oftentimes a barrier to entry into delivery of certain aspects of legal services is that with 3 years of legal education, et cetera, it comes at quite a large cost. But if you're able to do a certificate program for 6 months to a year, have a moral standing, et cetera, et cetera, et cetera, they might be able to help with various issues that be capped off. And if they'd like to proceed forward and be able to add additional responsibilities, they would take additional certificates or get fully licensed as a lawyer, just the same way that we see in the medical profession.
Okay, if I could just remind the folks on the phone, we're getting feedback from some discussion that's going on in somebody's office, and so if you could please mute your phones, it would be very helpful. Okay, other general thoughts Joanna.
I think we could be all in agreement that the recommendation could in fact be changed in such a way that we can elaborate what we're intending. Some of the concepts that we would like to see in the regulatory framework going forward, I think it should be included in the recommendation itself. It's not going to be a one-sentence recommendation like we have now, but I think we need to put in the detail about what we see going forward, including the fact that these areas of practice that we want to focus on are from the Justice Gap study that we're going to have concluded, and we want to rely on that. And that's why what we're proposing is going to help fill that gap. So we need to tie some of these together and just elaborate further on the recommendation itself.
Andrew just reminded me, another comment that we heard a lot was that lawyers are subject to the rules of professional responsibility, non-lawyers are not. So I just think that's another area of clarity would be, will there be a separate system? Will we be subjecting, anyone delivering services to clients that they are also bound by specific rules, conflict of interest rules, these types of things. So I just wanted to make sure I highlighted that as an issue.
Mark.
That raises a very interesting question, because part of the analysis here is if you're a non-lawyer and you're going to be allowed to give additional assistance beyond what you can today, let's just say there's a carve out on UPL, you get to do that. Should that carry with it the full panoply of fiduciary duties that lawyers have in the attorney-client relationship, where we are rendering full services with all the consequences? I'm not so sure. I'm not so sure that that's required. If the consumer is aware of what they're receiving and from whom, and whatever its limitations may be, I'm not so sure you'd want to cloak that person with the same accoutrement of fiduciary duties that you have with lawyers, because it's not the same relationship, it's not the same service. What you're doing is you're trying to deal with what Professor Sandiford said, is getting this person information. You have a legal problem. Here's what your legal problem is. Here's what the law is about. Here's what the solutions are. And then maybe I can make a recommendation to you. It's an unbundled type of service. But does it have to carry with it all the ramifications of fiduciary duties? I'm not convinced that it does at this point. It's an open issue.
Simon, okay.
I think we could borrow from the medical profession so that we don't necessarily have to start from scratch and see how they treat both. There's nurse practitioners, there's a whole panoply of like options that I don't even know enough about. But I know that they have regulations, et cetera, so we can borrow there. Also, that would also help for medical devices, software in the medical world. There are various aspects of that in terms of a device kind of diagnosing something, et cetera. And we could also borrow from some of that work there.
Randy and then Toby.
So one of the things that seemed to be missed in the whole public comment process, particularly at the town hall sessions, was the tagline at the end with appropriate regulation. And so it was largely perceived as a 100% deregulation model, which was never really the case. And so if you look at the other materials for this agenda item, with much appreciation to Mia, who issued on the NOBC, National Organization of Bar Council listserv, a question regarding the status of consideration of triple LTs. We have a table that shows what states have it, what states have studied it, which states have actually looked at it and rejected it. So I encourage you to take a look at that. We also have a table that compares the qualifications of the two programs that are the most fully rendered in the country right now, the Washington program and the Utah program. And the last piece is a reposting of the August 5th memo that provided the Utah proposed rules of professional conduct affected by their limited paralegal practitioner program, and the complete text of the Washington State Triple LT rules of professional conduct for Triple LT. And so, far different from a deregulation model, you could have something that borders, I don't know, we would say over-regulation of this option. But there ought to be a happy medium somewhere where you have the appropriate public protection level for triple LTs, as well as not so much of a regulation that you create a barrier that's almost as high as being a lawyer. And I don't think that's something that this group can do. So this is likely the type of thing that if you do something along the lines of what Joanna described, just describe the concept of a regulated limited service, as Mark was calling it, without committing or promising what it would be. If you say there ought to be due consideration, you couldn't imagine this going forward without some sort of financial responsibility. It doesn't mean you have to say, what is the insurance policy? What is the amount it has to be? Or that you have to create a client security fund for them. I think if you include that concept, it would be primed for the board possibly to hand it off to another body to do the heavy lift, which is actually building it, whether it's in a sandbox or a pilot program. That's what that group would decide. But we would have done our work because we took the public comment, we informed what this concept really should be based on that public comment, and we put it forth to the board as balanced as we could for them to do what they think is best. And so I think this is a good example. I was resistant to this recommendation at first because it wasn't really a technology-driven one. But to me, I think it's one that's the most doable. We'll wait till November to talk more about it, but I think we're on the right track with this one.
Randy, is that table in the agenda materials?
Yes.
Where in the agenda?
After you get to...
Attachment 1 and attachment 2. Attachment 1. Oh. It's a comparison of things that I've considered. Yes, MPP, and there's the email that Mia had sent to the NOBC. Attachment 2 for D1, it has the different countries and list the regulators are, what rules and laws that they're subject to, and as well
Mimi,
as-
you're saying D1, and I think it's D2, right?
This table is in D1.
What's the name of it again?
I see it in D2. There's
Yeah.
two attachments.
And then, and in D2, I was getting that. D2, it has to do with non-lawyer providing the triple LT and what each state does for that. Sorry, sidetracked.
Sorry, I might have confused things because Mia was so great. She did 2 points on the NOBC survey. She asked both about triple LTs and ABS non-lawyer ownership. So that's why these same attachments appear for both of those agenda items. So they do repeat because we asked for information from the NOBC on both topics.
Okay, Toby.
Just real quickly, and I notice it's on the chart. Another thing, we talked about the triple LTs, that seems to be the focus. New York has a system of navigators that I've heard, some pretty good things about that might be something we want to make sure to look at as well, where the person can not only give some advice and help filling out the forms, but can actually go into court with the person, not to represent them, but to provide support and to answer the judge's factual questions, if that's needed. So something else to include in that, taking a look at the navigator system.
Or another word for it, facilitator, right? They could be a facilitator.
Well, New York calls them navigators,
Okay.
and that's what it calls it on this chart. Yeah. Court navigators.
Okay, other general, yes, Heather.
Just one thing that keeps coming up, and I keep hearing the theme over and over again, is about the non-lawyers coming in and taking over and practicing law. And it seems that the fear is that it's just going to be random people off the street, random tech barons and other people out there. But we have a whole slew of people in the state of California who have legal experience, whether they went to law school and they never, with the 54% bar passage rate, we've got a lot of people who are not passing the bar who have graduated law school. And their degrees are basically have been nullified because they can't practice law. So they have to go in and do something else. We have paraprofessionals who are now being licensed and regulated in this state. We also have the means for people who've never gone to law school to be able to take the bar exam and become lawyers. So it seems that we're missing part of the discussion here is who would these people be out there? And by bringing into this that these are already people who are acting and representing and doing business in the state of California or have been educated in the state of California to practice law but can't, that it's there's a funnel here for these people. It's not just random people off the street. So it seems that when people are looking at the regulations, they're missing that connection. I think all of us in this room are understanding that these are people who are probably within the legal ecosystem who want to do well and want to do good by the people of the state of California. But I feel that there's a communication problem. And I think we're seeing that in the comments. There are communication problems in several different areas, but that seems to be one. But when there's this fear, and I felt that we heard it today about how this is going to encroach into a lawyer's life. Well, we've got a whole group of people out there who are trained, who are educated, who have no ability to give back because they couldn't pass the bar exam. So I think that we could also be opening up a way of giving people who have who have all the same loans as everyone else. They just don't have a law degree to now practice. So I think there's something that we could do there to explain better and also to provide that it is a solution base that we're talking about. We're not trying to take away, but we're trying to add to, and it would probably open up a lot of jobs to people.
Mark?
Yeah, you've raised a very interesting point because there's many people I've run across when I was teaching who had no idea if they wanted to be a lawyer or not. And so they went to a law firm, they became a legal secretary or a paralegal and spent 2 or 3 years learning about the field of law before making that decision. Here's another opportunity, it seems to me, for people who could be licensed to render these types of services as a way of becoming more versed in the field of law and perhaps becoming a lawyer at some point in time.
I just want to take a moment to, this task force was very exciting to me because of the makeup of the task force. And there are experts on this task force in very specific portions of legal, and they are not licensed to practice law. Their skill set is not that of a lawyer. And thank goodness for that, because the legal industry would not work if it was just lawyers. So I want to back up and think about why we keep saying if we let others into the industry, non-lawyers, we're going to destroy the profession. We're kind of here. We've been here a long time. The truth is the industry is made up of professionals with very, very, very different skill sets than lawyers have. That is necessary to allow lawyers to do their job. A lawyer's skill set is not great at doing some of the things that these professionals bring to the industry. No industry is made up of one skill set. And I think we are struggling in the legal industry because we have devalued all of those other professions and lumped them together to say you're either a lawyer or you're not. And what I did as a legal secretary with 6 weeks experience versus what I did as a very experienced trial litigation paralegal versus what I do now as an operations expert are all different skill sets. And none of those should be conflated and confused and sort of lumped into the same category. Neither are the other individuals on this task force who do things that are very different than all of those. And so I want us, as we're talking about these regulations, to maybe think about the positive side of reminding ourselves, the court, the people who vote on these, and the people who are really genuinely concerned about true problems, just to sort of go back to reality of, hey, non-lawyers are already not only in the industry, they're vital. So let's stop pretending like we're somehow opening some secret door that they didn't know was here, and be real about they're already providing these services in a variety of ways. We're just overwhelmed and can't meet the need, because I don't think it's for lack of want or effort.
So Bridget and Mark, are we ready to move on beyond this one? You're good? Okay. The one that I've got that we're going to talk about next is obviously very closely related, recommendation 2.1, which is D1. Entities that provide legal or law-related services can be composed of lawyers, non-lawyers, or a combination of the two. However, regulation would be required and may differ depending on the structure of the entity. And that I've got that's Joanna and Mark.
It was Joanna and myself, but Joanna spearheaded this one.
Oh, I'm sorry.
so-
Thank goodness for that.
Mark is going to actually take the next 4 hours to go through that. So
Thank you, Andrew.
Okay, well, we heard a lot of comments on this particular recommendation earlier today.
Okay, if let me try one more time. Folks on the phone, really, it would be much appreciated if you would mute your phones. We're hearing paper shuffling and talking and one thing and another, so thank you.
Okay, so on these, I like we did the last time, I'd like to just have a discussion among the group about the recommendations and the concerns. I see the comments more as concerns being raised, and can we address those concerns with what we're talking about? And I'll start with one of the recurring comments that law firms would become accountable to shareholders and not their clients if we were to allow non-entities to have ownership, or non-attorneys have ownership interests. When we were talking about this as a group, we made it clear that the rules would still apply to attorneys, that they would still be obligated to put clients in the courts first before the entity, and none of that was going to change. That was clearly lost on the people who are making the comment. They did not absorb that information, and we clearly didn't communicate it well enough, so we need to make that clear going forward. But there was some things about the comment that I found very disturbing. In particular, the suggestion that if you're not a lawyer, you're going to be corrupt. And you're going to bring corruption into the entity, and that you're only going to put profits above everything else. I don't think that's a fair assessment of the rest of the world. Clearly, there are bad actors among lawyers, just like there are among people that are not lawyers. And the same is true with corporations. But I think that we can address these concerns the same way we do with attorneys, with our ethical rules. We can have requirements in place going forward. In my response that I was drafting, I cited an example of Slater and Gordon, which is a multinational law firm that went public. They have shareholders. And in their initial public offering, they made it clear that they put the courts, clients first before shareholders. And so when you invest in that entity, you're accepting that and you're recognizing that revenues don't come first. There's no reason why we cannot make that requirement going forward if there's a non-lawyer ownership of a firm or a business. You also see it recurring, the suggestion that lawyers are going to become corrupt if they have non-attorneys over them in some respect. Considering that we have in-house counsel where attorneys are working in a corporate environment, yet they're still required, if they see wrongdoing occurring by their superiors, they're required to report it. You know, that should feed into the discussion, and we should point this out going forward. We also have a situation where law firms get loans all the time, and so they are then beholden in some respect to the financial institution in which they get a loan. But that doesn't mean that law firms are putting the financial institution's interest ahead of their clients. There's always going to be these competing interests. Lawyers have to pay their bills, so they have to put their family, in that rank somewhere. We've managed, for the most part, to do it without any ethical problems. And if anyone's worked in a law firm environment, you're fully aware that law firms put revenues first. They're a business, regardless of what we want to call them, and regardless of how high we like to think of ourselves over these ethics issues. Profits per partner are how things are measured in the law firm environment. It's about the money. If you've been in that environment, you've seen bill padding, fraudulent billing practices, minimum billable hour requirements, all in an effort to increase revenue, and the pressure is true, it's there, and it happens. It's just very hard to catch. So we're not holier than thou as attorneys. People who are not licensed attorneys are not all corrupt. We have to recognize that we're all in this together, and we need to find a way to make it work, and it can be done with the proper regulation. So, before I move on to the next issue, I don't know if anybody wants to comment on that.
Lori.
Shocking, it's Lori. I have two questions, and I'm going to ask people to raise their hands. So for those of you who are not licensed to practice law on this task force, how many of us believe that lawyers are so easily corrupted that a little bit of money is going to make them go against every bit of their ethical obligations? How many believe that is going to happen? Okay, so this task force, those who are not licensed to practice law, are really believe and have faith that lawyers are not corruptible by money and will continue their ethical obligations. Now let me ask the lawyers. How many are lawyers? Because I forget.
Yeah, how many are lawyers?
So of those lawyers, how many of you are like, hey, I will never partner with a non-lawyer because I'm going to be corrupted? I think that's a valid point. I understand the idea behind it, but I think the reality is those of us who are wanting to help make this industry accessible to that 70 to 86% who don't already have access believe in this profession just like lawyers do. And I just want to go out on a little positive note, and maybe we can build that in. I'm not going to say I know a bunch of bad lawyers. I know bad everybody. We all do. I actually know a ton of amazing lawyers, and I trust their judgment to help build the best service possible. And I just want to offer them skill sets that they don't have. And so I'd really like us to maybe consider the positive side of that, because I think it's very hard not to get caught up in the, well, you're bad too kind of argument. And I think if we can build that into some of our responses, we can remind people how excited we all are to really help meet those needs.
Joyce.
So I'm just going to add, as somebody who already partners with lawyers to create technology tools that, I mean, granted, we're a nonprofit, we don't make any money, but I mean, I think those same people would still partner with me even if we were going to figure out a way to make sufficient funding to make it possible for my nonprofit to survive without grants. I mean, I think there's just a lot of other, models that this would allow for that might really make a difference for low-income people that has, just because I would love to be able to make money. I would love to not have to write grants. I would love to never ever do funder reporting again, because I can tell you it's a ginormous pain, right? Like, it would be great if we could make a little bit of money somehow. And I think, the idea that the minute that all the lawyers I've currently partnered with, the minute if I figured out a way to be able to make money, that they would somehow become greedy and, suddenly change their sort of ethical position is, something I think we do need to communicate. And I do think that a lot of the comments just generally have really focused on the for-profit and not necessarily the opportunities that might be afforded to not-for-profits. And that's another place where, not for-profits doesn't mean that I can't charge for the services I provide. It just means that the profit motive isn't the thing that is not how I measure my impact, and it's not how I measure my success. We don't charge anything because that is a fundamental position that our organization has taken. But I think you could say for-profit organizations could make some money and fund to some extent with some of those profits, not, arms of that organization that don't necessarily charge. So I think that's the other exciting part about some of the alternative business solutions, is the idea that you could have something that, in a certain practice area, you might charge money. In other practice areas, you might not, based on sort of the access to justice component that you're trying to address.
Andrew, and then Leah.
Well, a couple things. I just wanted to highlight, and I'm going to say this on purpose. I really don't care what we think about this, and I'll tell you why. Like we draw hands, et cetera, because we need to actually try to get the public to tell us what they think should be happening. And ultimately what's happening is we all have come to this table with various biases. And traditionally, when you look at and if I can get meta for a second, when you look at law, it's an adversarial system. And generally the way that we are taught to think, both individuals who have a legal education and people who work in our space, is we want to prove a point. Let's call that point B. That's what our client comes to us with. That's the outcome they want. And then we read a variety of information, and then we try to support what our position is, which is point B. We don't, in the process of examining all the points, try to find things that would necessarily hurt our arguments for our client. We do so and find them in order to best respond to objections from our opponent, rather than say halfway through a trial, you know what, you're absolutely right. I actually think my client should be sentenced much more severely than I actually had laid out. That has never really happened, and that doesn't happen. So why I say that is it's led to what I continue to see, this kind of adversarial approach to this entire process, where it's like, do we all think that if there's non-attorney ownership, things are going to be bad, things are going to be good, et cetera? And ultimately, we're forgetting the fact that there is a sign outside that says we're supposed to be protecting the public. And I think those voices, I've asked as many people as I can informally. It's completely anecdoted because I can only have as many conversations as I can. And the public wants certain things. Now let's get those voices in here, because those voices would be much more important to hear than anything that we've heard, the comments from the public, and anyone in between. Let's not lose sight of that. And I find that sometimes if we feel so strongly that we're right, coming into both sides of this, we're going to fight over that rather than fighting for better access to justice for everybody.
Leah, and then Toby.
I just have a question, and forgive me because I'm not as familiar with all of this material as you all are, but could you explain how this 2.1, how it does and does not relate to the options for 5.4 that we discussed. Is this an area where they are mutually exclusive options, or how are they similar and different?
Well, I can take a shot at this. You couldn't have this without dealing with 5.4 because it would involve fee sharing. So if we decide that this is a direction we want to go, 5.4 is going to have to be looked at, and we're going to have to decide what exactly we're doing with entity regulation in order to know what we need to do with 5.4. So they are directly connected. They're not mutually exclusive of each other. I mean, you could do 5.4 without this, but I think the problem with that is we want to make sure there is entity regulation. If there is fee sharing, there's regulation associated with it so that the concerns about that can be addressed. So I really think it's better to look at them as not mutually exclusive in any way.
Wait, it's Toby's turn and then Mark.
I'd just like to ask Andrew for a second. I know I spent many years trying to get public opinion, public input on the priorities for the legal aid program that I ran. It's an incredibly difficult thing to do. And there are 35 million members of the California public. How do you decide which ones you reach and how you reach them? And how do you then know that you didn't exclude a whole category that, and I'm not saying we shouldn't get public input. That's clearly important. But the problem I have, and I've had for years, is how do you define the public and then reach out and actually get them to participate in a meaningful way?
I think the first stage, again, and this is with a caveat that I don't have any of the answers at all, but I would say if it was up to me and I could wave a wand, one of the things I think I would do is ask individuals who are currently in contact with the legal system, what are their experiences, what their suggestions for improving it would be. And so, if individuals are at every aspect, small claims court to civil matters, et cetera, and capture that data and make it actually a requirement that they provide that insight. At the same time, I think we've all know that one of the largest issues that we have continues to be that individuals either don't identify their issues as legal or are scared or intimidated by the legal system. So I think one of the things we need to do there is improve legal literacy. So educational programs from elementary school to high school being a requirement for individuals. Now, I know that this seems like I'm saying things that might, well, Andrew, in order to get that done, we're going to have to change everything. But we have to have aspirational goals, and we have to try to set that out there. But I don't think it actually is that crazy to suggest that as part of interacting with our system, individuals will provide feedback as to kind of how things went and their suggestions for improvement with that. Now, in the short term, if we're looking for better public commentary, I think having things at different political events where we also have large groups getting together, having stands, having grassroots efforts, launching TV campaigns, billboard campaigns, social media advertising, et cetera, would be necessary. While that does seem like a large cost, I think we would have to try to find a way to also see if the public would be open to using additional funds that we would have to make available throughout this process.
I think that answered my question to some extent, in that it's impractical to do that in whatever time frame we have to do this. Even if we extend 3 months, 6 months, we're not going to change the education system. Even your short-term stuff, to do a massive community education campaign, even if we had the funding, probably would not produce results in that kind of time frame. My other thought is, it seems to me your comment about talking to individuals using the system is exactly what Professor Sandefur did in coming up with her ideas and her thoughts. So we have that data.
I think we could double down on that as a practical measure, but I do think in terms of what I continue to see as an issue is that we are sitting in rooms debating about issues that affect the public when the public isn't present, nor are their voices being heard. I don't have the answers to that, but I do think that it's a huge issue.
Mark.
This recommendation 2.1, brings into play, in my opinion, ALSPs, alternative legal service providers, which are not necessarily law firms, and which are made up of lawyers and non-lawyers. It's a very robust, growing, dynamic field. May or may not involve 5.4. I mean, it may, if you want it to, but it hasn't so far, and it's growing by Topsy. And some of it's good, some of it's not good. It's not regulated. Some of us believe 5.7 would be of aid for lawyers who are combining with non-lawyers in these kinds of ventures, because they involve litigation funding, which has a lot of pros and cons to it. A lot of other things that are growing. Artificial intelligence, it's a booming business, and law firms are deeply involved, investing hundreds of thousands of dollars, owning, buying, operating these companies. In terms of the legal, because this says provide legal or law-related services composed of lawyers and non-lawyers, so it involves a broad array of entities. On the legal side, that gets us back to the discussion we had in the prior recommendation. What is an authorized service? So if you had an exemption on the UPL statutes, for example, that allowed certain additional services to be authorized that wouldn't be UPL, you could have an ALPS that would cover that. Once again, you wouldn't have to do away with 5.4. So they're not connected at the hip. They are connected, and you may want to do something about 5.4, but you're not required to. It's an alternative.
Lori, and then Alan, and then Kevin.
I give it to Alan and took it back. I'm wondering if maybe we can, so I think Toby brings up a very good point because I think there is an overreaching theme that we all recognize. Consumers, true legal consumers of legal who are not getting their needs met, aren't in this room, aren't reading these proposals, aren't responding. We all accept that and know that's true. And I agree 100% with Andrew that we need to fix that. But I also recognize that is not going to happen in 60 days, 90 days, maybe 600 days, maybe even 60 years. We have a lot of undoing to make some of these things happen. But can we, as a task force, as we are considering all of the proposals, maybe approach them from what gives consumers the most options? Because the consumer's voice might not be heard in this room, but they have already loudly said, I am not coming to this profession under this current system because I don't know or I don't trust. And we're finding that I loved hearing the data that supports that it's not just low income, it's not just underserved because of poverty and things of that. It's not a means issue alone. So I think this task force can represent each of those people by not necessarily fighting for what we think is the best solution, but maybe what is the best, what provides the most options. And consumers will actually vote with their dollars, and they're showing up and asking for those services. So maybe that's another way we can look at this, is giving them a voice by giving them options.
Alan, and then Kevin.
So I just wanted to respond to Mark's comments about 5.4, just to kind of give an actual practical example of how this can play out and benefit innovation. So I have in my inbox right now an email from a law firm that wants to offer a subscription-based legal service. And I do a lot of work in this space, and the reason why that's important is because subscriptions pull the barrier of entry down for the consumer in accessing that, and it provides recurring revenue for the law firm, increases profitability over time. There's lots of benefits. I won't go into that detail right now. But it costs a lot of money for me to build that technology and give that to the law firm. And this small law firm, single lawyer, is very interested in doing this. His heart's in the right place, very ethical lawyer, but he can't afford it, right? And I can't afford to actually do it for him, right? Unless I was a nonprofit writing grants or something like that. I'm not getting into that business. So yeah. So, but my point is, in his email, he wrote, "Hey,
can we just kind of work this out where we essentially split the fee? He doesn't know he's asking me this, right? Like, yeah, I don't think he's kind of thought this through, but he's essentially saying like, could you just not deploy this, right? And then I'll pay you based on like, as my law firm grows. And I was like, that's what we're trying to accomplish, right? But under today's law, we can't do that. So again, my point in bringing this up is an example of how there are innovative law firms out there, innovative lawyers who are thinking this way, and then realize like now they find themselves caught up in the rules that prevent us from kind of creating these innovations. So.
Okay, we got Kevin and then Simon and then Mark.
Okay, I don't want to jump on the bandwagon and attack Mark. I just wanted to point something out. I think it would be very easy fix to 5.4 that would fit hand in glove with what Mark is proposing. What Mark is proposing, as a reminder, and let me make sure I have it correct, it's not that you define the practice of law, but that you provide for exceptions to the unauthorized practice of law, like as we already do in the rules of court for in-house counsel. They don't have to be admitted in California. They come in and can, represent and continue to represent their client, the corporation, the business, that they are in-house counsel. So just by putting in Rule 5.4, unless something along the lines like, unless otherwise permitted by law, a lawyer may not share fees. So in other words, there's a general exception that's carved out. Then that's going to leave it up to the courts, or as Mark said before, God forbid, the legislature, to carve out an exception to UPL. And it would be covered. But we have to remember, if we're going to do something along those lines, there's always going to have to be some kind of legal regulatory framework that permits it. And one of the approaches would be the sandbox that we've all been talking about, which seems to beginning to make a lot of sense to me. And not just beginning, I guess.
Simon and then Mark.
It is related to that. Is that okay? I was just going to say the same thing, and also with the sandbox thing, I think that would be a way that we could also track the public's experience, right? Because one of the things we were talking about in our subcommittee would be, if we do have a sandbox and we do permit certain entities to practice, we could attach a data requirement to it so that they would be tracking their users, and we could have certain information that we think would be helpful and inform this process with people who are actually encountering the legal system at that time. And I think, anyway, I just wanted to throw that out there, something we have been discussing in our smaller subcommittee as something that's very important.
Simon.
Yeah, so to me, Joanna really just was pulling at my heart with that description. I mean, to me, for the past 3 years, it is so frightening that people really feel this way. As someone who did not go to law school, but in the past 3 years that I've been in legal tech, the only reason why I'm doing it is because there's a huge problem, and I like solving problems. And I've started companies that have barely been able to meet pay for employees. And it wasn't about the money, that it was always about fixing a problem. And of course, there are bad actors everywhere. There are people always want to make a buck. But to me, again, and this was Andrew's earlier idea, and I just want to reiterate, and I don't want this idea to get lost, is creating a one-page or just making it easier to communicate what the real incentive for these ideas are. It's my understanding that when this was posted online, that there was some 200-page document associated with it that helped to explain what we're doing here. And to me, going back to when the Constitution was first being written and all of these Federalist Papers had to be written to help to describe what we're doing, is because lawyers and many other professionals are such hard-headed that we have to think of creative ways to get the message through that we have a real serious problem. And real Americans are impacted by this. And if lawyers think that they're so that they have the solutions to all of these problems, then why hasn't the access to justice problem been fixed? Why are we talking about this? Yeah, I would love to hear from all the people who spoke earlier today if they would take a case that was below $20,000, below $10,000. Because I've spoken with people in San Francisco that, yes, some lawyers open their doors, but for the vast majority, they don't even know where to look. And so to me, the heart of what we're doing lies within 2.1. And the opportunity for us to really address this starts with this. And I think rather than thinking like lawyers, where people, someone comments and then we come up with a response, to me, that's just so archaic. I think we need to think more creatively about how we communicate with people and how we can get broad general support around this, because otherwise a group of people are just going to ruin the pond, poison the pond, which I think what we're starting to witness because we're not aggressive enough and being clear of what our intentions are, because these conversations are so rich, authentic, and I think collaborative, and so many different perspectives. And when we communicate outwards to other groups of people, to me, I'm not sure that's necessarily being portrayed.
Mark.
Trying to remember why I raised my hand. I think it was a comment some time ago about the barriers to lawyers and non-lawyers developing combined services together. And let me just say that I thought, and I think I'm on the record on this, if you read the Utah report, which is, I think, much more, I'm sorry to say, cogent than our report, it gives you a pretty good insight as to what they propose in terms of implementation of proposals which are not too far removed from what we're proposing. They're not proposing a complete do-away with 5.4. They're talking about the sandbox approach where people can come to them with proposals that might allow for some relaxation of the rule in a given setting for specific practice, for specific need that's been identified as a critical need. Who can disagree with that? I don't. But that's a far cry from what we're hearing in terms of 5.4. The second point I want to make is that in reality, speaking of reality today, there are combinations of lawyers and non-lawyers providing law-related services to the public involving artificial intelligence without any barriers whatsoever. And I represent a number of those firms. I should introduce you to Wilson Sonsini and Littler Mendelsohn. They've got enormous programs involving lawyers and non-lawyers that provide law-related services. Now, you could tinker with that and allow for an additional service that might otherwise be characterized as a legal service and build that into what they're already doing, and you have not done a complete upheaval of the legal services business. So there are innovative ways to combine legal, non-legal services. All we have to do is be creative, as we say, and we don't have to just tear up the rules and do a complete do-away. We can come up with some pretty creative solutions that gets to the areas of critical need without doing violence to the legal profession.
Yeah.
I might add to the justice system, which I think is just as important as what consumers want. It's about the integrity of the judicial process.
I'm going to leave most of what I've got to say until we discuss 5.7, which is relevant. I included in there as well. Except here's the problem with the lexicon we're using. It's the concept that we've got an attorney using AI, okay? So we're trying to scale the attorneys. If we just look at the legal landscape report or any of the civil legal needs studies, they're coming up with the dollar amount per hour that an attorney has to charge, and shows them operating at about 25% efficiency. So at most, to take one lawyer and scale them, you get up to about 5 to 1. Okay, and that's if I round up, they work 10 hours and they work on the weekends. Okay, technology, AI, starts at 10,000 to 1. Okay, the lawyers, we can commoditize what the majority of lawyers do. That's the point. I'll leave the rest to 5.7.
Okay, are we at a point that we can move on? Let me ask Joanna and Andrew, anything else that you need with respect to this particular proposal? Yeah, oh, Bridget, I forgot, I'm sorry.
I was just going to go back to the point about not, it is difficult to hear from people, but I do think it would be helpful to me anyway to have some kind of town hall where it is not a bar association that we're hearing from. I just think even if, and to me, one group I think that would be helpful to hear from in a concentrated way would be legal services, because they are the ones that are on the ground talking to people. They know what kinds of cases they have had to turn away and what kind of real concerns that they do have with what we're talking about. But people that do come in contact with the public and actually hearing from them, I think would be really important. And beyond that, I think stories like what Alan just shared, hearing, to me, anecdotes of actual stories of people that are running up against, here's what I could deliver, but I can't because of the law, and actually seeing that instead of talking in abstract, which is I think what we're doing most of the time, I think would be not only helpful for us, but for the public when they're trying to digest what we're trying to do.
In Sacramento, we had a very large, at the town hall, a very large presence by the Paralegals Association. I don't remember if they were California-wide or
The LDAs, the licensed
legal
doctors.
Oh, okay, yeah. It was great to have them. They gave us a really interested perspective, so that was great.
Leah.
I wanted to say, you all may recall at one point in this process, there was a discussion about issuing a survey to try to get public input. And at the time when we were trying to develop this, it seemed really abstract, very difficult to figure out what questions would be asked. I think we may be at a point where it would be appropriate to reconsider that. We were going to go through NORC to do that survey as well, because they have several panels set up and you kind of specify to them what kind of demographic you're looking for. But it may be that it's time to reconsider that, and that is something that could be done in the next couple of months. So if that's the will of this group, I think you could ask staff to kind of revisit that issue and bring back in November an approach to a survey.
That's a really good idea. Really good idea. Heather.
Yeah, two things really quick. Jumping off of that is, we have enough contacts out there to grab people together, rather than doing a town hall, but bringing together a focus group of people. And we have access to people who are already in the system looking for legal services, whether they're going to VetZedek or some of the other organizations out there. So there is access to people. We just have to call them and invite them in. And that's just a little bit of a process there. The other thing, and Joanna, I know we were talking about it at lunch, and getting back to the whole corporate entities coming into this. Law firms right now are corporations, and they're set up as either C Corps or LLPs in California, and there are already shareholders and the partners of the firm and how they're structured. They're already structured for all the decisions being made, whether or not to take on a case or not take on a case, whether to let a client go, whether to keep moving forward in a case, whether you settle a case, all based on financial decisions about how it affects the partnership as well as the legal service. So we already have that model in place, and it's every law firm in California. So, there's already precedence there. It just needs to, once again, I think it becomes a communication issue, and that's what we're missing, is that we're missing connecting those dots. And I think it's coming through loud and clear in the comments that we got, but also the discussion that we're having today.
If I can just put a bow on it before we move on.
Please.
I think the one thing that we need to make sure we communicate with regard to entity regulation, well, make it two things. One, we need to tie it to the access to justice problem and how this is the way we create the one-to-many solution versus the more one-to-one options. And it's the one-to-many solutions that are going to really move the needle on access to justice, and we're not able to do it in the current environment. God, now I lost my second point. Anyway,
That was a good first.
that was a good first. Maybe I should stop there. I remember the second point. The second point is we already, as it's already been mentioned, have a number of operators out there that aren't regulated. And until we do this, we're not going to fold them in and be able to regulate them. And we want to stay ahead of technology. We want to be able to say, if you're going to be in this field, you need to maintain the data. You can't share it with anybody, the confidentiality issues, those things. We need to get ahead of the regulation. And right now, nothing's happening, and they're out there, they're not being regulated. So this is a way for us to make sure that those that are out there in that environment can come into the fold and be regulated in order to protect the public. But I think we need to make sure those concepts are clearly communicated so people understand why we're even talking about this.
Okay, on that note, then the item I've got up next is recommendation 3.2, the adoption of the 5.4 alternative 2. Did we already exhaust that discussion this morning? Yeah.
Justice, have we met? There's a couple more things we could say about that.
Okay, so jump in.
Well, I think this is an overreaching concept that I wanted to think about when I was reading the comments. I take the comments very seriously. All of the fears are valid. There's not one person, I think, on the task force who doesn't worry that in our drive to increase access to justice, we hurt the people who need us the most. And for those comments that say, for-profit is going to destroy the legal profession, we're already for-profit. The legal profession is not nonprofit. It is for-profit. There are nonprofits existing in the space, but lawyers are for-profit. So I don't think we have to spend a ton of time on that. I think what I really wanted to think about as I was drafting responses with Tara, and I think Tara and I talked about this idea very much, is we wanted to bring about the positive side of this. I've been interpreting between consumers of legal services and lawyers for almost 20 years. That is part of my skill set and my job as I have served this industry and served those consumers. And the interpretation, the communication, the process of helping consumers and lawyers hear and talk to each other is not necessarily part of the skill set that attracts lawyers to the legal industry. So communication is key as we kind of move through this. And the reason why I think sometimes there is this communication barrier, why people don't know they have a legal problem, why they don't trust lawyers, why every lawyer joke starts with, they're money hungry and profit driven, and yet I know a lot of poor lawyers. I think it's a communication and perception issue. So I wanted to think about, as we were talking about our possible responses, how could we positively or in a positive mindset help lawyers see how this is actually empowering lawyers to serve needs that they cannot serve at this moment. The truth is, statistics, data, everything is telling us, and I don't think if you have actually done the research that you can, with real conviction, say the answer is one-to-one solutions. We recognize as an industry, a profession, a court, all of us here know and have heard too many times now that the answer is not a one-to-one solution. There are not enough lawyers or hours in the day to meet every legal need head-on with a one-to-one solution. And so in order to scale, we must look to industries that know how to do that. And that is not our industry. And so I think that these proposals empower lawyers to bring their very necessary skills and knowledge in a way that they cannot see now, or if they can see it, in a way that they cannot afford to now. And we should not think that profit means dirty or that money equals bad, because the reality is, I heard a lot about Uber today, and I'm sort of laughing at that idea since I was down at this super awesome festival in LA yesterday, and I'm super geographically challenged, and I was very grateful for the Uber guy who didn't make any profit, who brought me back to my hotel. Uber serves a need that was unaddressed and unmet. And so whether we like it or don't like it isn't really the point. I have Uber and I use it every day. Consumers are using that every day. It's about giving our consumers the option. So I just wanted to be, I think our responses as we drafted them remind us a couple of things. Law firms are inefficient. Every bit of data that we have in this industry supports the idea that the courts are inefficient, the law firms are inefficient. We are unable to meet the vast need. That is not a judgment on lawyers. That is not a judgment on our court. That is simply the current status. And so looking to others to partner with us, truly partner. And a partnership means reward on both sides. That reward is how we keep people invested. If we simply say, come help these people because they need us, then we don't attract the top talent. And that's simply what is going to happen. And we can argue about why it shouldn't or why it should. I'm very excited about the opportunities. I'm very excited about how I can envision lawyers partnering with people who have diverse skill sets and what they will create. And I believe those lawyers will create those opportunities. We just have to allow them to partner with the rest of the professions and skill sets that they need to fully imagine how they can provide those legal services. So I think if you spend some time on our responses, my goal was not to say, for every corrupt lawyer, there's a corrupt business or vice versa, but really more like focus on the realities of our current system and the possibilities, which is what we're really talking about from a really positive standpoint. I think the last point is to remember we are an adversarial profession. Lawyers are taught to think and be risk adverse. And that skill set is absolutely necessary. It is also the exact opposite of what is needed for truly innovative future movement. And so allowing lawyers to remain risk adverse, but giving them ways to partner with people who can see possibilities that are not natural to the profession is, I think, how we give consumers a much wider voice and a much larger set of opportunity to decide what they need from our profession and not what we decide they need from our profession.
Tira, anything to add? Any discussion, or can we move on? Okay, thank you. We're going to move now to recommendation 1.1, which is D3. Models being proposed would include individuals and entities working for profit and would not be limited to not-for-profits.
That's me.
Anybody didn't get the
Is Andrew.
printout this morning? This came from Andrew this morning. It lists a couple of the comments that we brought to his attention. I think some of you guys grabbed them, some of you didn't.
If you didn't grab it, I don't think it'll add that much of a difference. I'll review them very quickly. This was the suggestion around models including for-profit and not-for-profit. We've already had a lot of discussion on this point, so I don't think a full examination and in-depth conversation on it right now would add anything to it. I do think that there were 3 comments that I chose to highlight. The first one really spoke to the concept of right now, it's hard to find legal work as it is. Would this lead to an increase in competition for attorneys who are already struggling? And we've heard examples, and I myself know the struggle of that as well. I was at a small firm of about 4 lawyers, and it wasn't always easy. I think that that to me means that when we are providing our reply, I think an examination and kind of an exploration of how some of the things that we're proposing around various levels of certification may lead to actual more legal work and more opportunity for legal kind of professionals to be able to provide more services to a public. I think one thing that we often forget is that with the access to justice gap is a lot of it is that people can't afford legal services as they're currently being delivered, but would need to access and would want to access legal services people go and sign or work hours without getting paid for overtime. They would love to be able to fix that issue. I've signed countless leases for properties without having anyone oversee that. There's countless examples of how we all would want access to legal services but don't. And I think that we've already talked about that as a group, but I think that that was the first one that I highlighted. The second comment that I highlighted, I think, went to the heart of the fact that profit may possibly erode possible access to justice initiatives if things are for profit. I think one of the things we could do there is perhaps ask law firms as well as other legal organizations right now that do draw profit through the delivery of legal services, their best practices and tips for how they currently separate out kind of their interest from the profit, because I think they are doing it right now. So maybe they have kind of best practices we can learn from, especially when you consider things like profit per partner being a key metric and North Star at a lot of law firms. I think if they're able to separate that too, perhaps we can learn from that model. That's something that was kind of a comment that I saw throughout. And then the last one was about how the unlicensed practice of law essentially would erode the protections of the profession because right now there isn't enough data to essentially prove that any changes would allow for better access to justice. I think in the replies, that's a really good point. I think we're seeing that throughout different places. I think that is obviously a chicken and the egg issue, certainly. We know that the status quo things are not working right now. And I think perhaps even as we open up for recommendations in the future, one thing that I'm sure a lot of individuals would have loved to do, but maybe it wasn't unclear in the instructions, would be to provide alternatives rather than what we suggested, because that would have been really, really helpful. And I'm guessing that the instructions weren't clear, and that's our fault. So if in the future we also allow for individuals not only to say, hey, I disagree with this idea, but to provide their recommendations for what possibly may work, I think that would be super helpful. But I think it's a really good point to be made that we're going to need to have that data, and I think there's different things we can do to go forward with that. I think ultimately those were the three that came to mind, other than what we had, and I think they did a good job just in showing some of the consistent commentary that we got. That being said, I would say that the commentary for this was also in some cases copied and pasted verbatim from other places. So it's the similar discussion that we had here would also cover a lot of what else that happened in that discussion.
Great. Joyce.
So I just want to make a kind of a general comment about data. I was asked to do the review on the recommendation regarding the establishment of success metrics, which was a recommendation I made. So I felt really good about the fact that they asked me to review the comments that recommendation generated. And I will at some point do the formal report when we get to me on the list. But I think generally just in terms of data, since it seems to kind of keep coming up, I think regardless of what we end up deciding to do, having a set of evaluation metrics set in place so that you can capture baseline data both in a qualitative and quantitative way prior to the implementation of any kind of modification to the regulatory environment is critical. And I would say the other thing, just generally speaking, is that we are never going to be able to successfully rebut a lot of the comments that we are receiving about the sort of what I think of the doom and gloom, apocalypse is fast approaching, zombie, whatever war that might happen once we start tweaking with the justice system. We are never going to be able to rebut those kinds of comments successfully without objective, credible, qualitative and quantitative data that's been collected from the beginning that measures impact. And in the responses that I modified, the ones crafted by the California Bar staff, I refer to a number of national efforts Specifically, the ones I'm thinking of, which I did not include specifically in the response because I would like this body to be able to make a decision about what they want to mimic. But the National Center for State Courts is doing a significant amount of work around the Drake equation formula, which my organization came up with, which as a way to measure sort of a technology tool's impact broadly on the access to justice gap. So I think there are lots of ways besides just sort of surveys and the standard academic methodologies that are out there. I think there's some really interesting stuff, and I think this body should seriously consider having Tom Clark, formerly of the National Center for State Courts, come talk about his work refining the Drake equation, and the Pew Charitable Trust folks. Erica Ricard is in charge of their recently created Civil Justice Initiative, which is looking at these exact opportunities to measure and understand the depth of the impact and how changes that are being made in a variety of ways, whether those are simply technology solutions being deployed by legal aid organizations, stuff like what the Florida Justice Technology Center is doing, as well as these regulatory modifications that are happening around the country. So I would offer that as something that, should the timeline permit, and I know that that is somewhat in flux, those two individuals, I think, in particular, would be extremely beneficial, because you're going to have a common, credible data set that everybody agrees. And then what you argue about is how you interpret the data. But believe me, that is a step forward to the conversations that we're having now. So it's a baby step, but it does get you kind of down the path. And I just can't be quiet anymore. So I will do the formal thing whenever you guys want me to, but just in case we don't get to me today.
I would just add that I was super happy to see how passionate folks were in their responses, and I think we're really lucky to have so many individuals out there who care so much about this subject, so I think we can't lose sight of that. One thing, though, that I think is important, too, that we could perhaps stress here is that it talks about including for-profit entities and non-for-profit entities. I think stressing the fact that law firms are already for-profit would be a good point to make. And I think the issue might come down to not necessarily the profit, but the regulatory framework that surrounds that, because individuals know that if they only act within the kind of interest of profits, that they could be disbarred, and there's other kind of penalties. And so perhaps us kind of showing what penalties and what certificate programs might exist could go a long way, because I don't think anyone would argue about the for-profit aspect unless we want to make all law firms essentially non-for-profit entities, which would be an interesting take, but I don't know if law firms and legal organizations would want to do that. But I think that that's important to stress.
Lori.
So I'm pretty sure this is related. So sorry, guys. But Tara and I actually didn't talk about the comments that we had pulled out. But one of the comments that we had pulled out from the standard responses was actually, and there were maybe two that were kind of related, that actually talked about the idea that as the industry stands, it fails. Like, we're on a failing streak. There are certainly studies that have said the access to justice gap has increased, even as we're trying to make these changes right now. And so one of the comments was basically talking about how the idea of innovation and technology are how we help the legal field become a fully functioning, successful, profitable place to be, so that it can continue to serve. And so it kind of turned the idea on its head a little bit of, can we also approach this idea from success in the legal field means success for those consumers, and without actually opening up the idea of true partnership, investment opportunities, technology opportunities, other types of legal services, are we actually keeping the legal field on a path where it eventually implodes? And so I thought that was kind of connected to this idea of we want to track the data. I'm all for, Joyce, I'm right there with you on the data. But also being mindful that the data shows we're on a downward slide and it's not stopping anytime soon. And so how we think about success and profit, because profit is what keeps this industry moving forward. So.
Neil.
Yeah, so the issue of profit, of course, is being talked about a lot from the commenters and this group as well. The only thing I'd like to point out that I haven't heard yet today is that, sure, law firms and lawyers will work for profit, but that's always tempered by the rules of professional conduct. And there's that always that tension. And when that tension breaks, that's when it's a discipline problem. And I think what the commenters, their concerns are is that by bringing in outside capital, bringing in non-lawyers, you're adding to that tension belt. And which then informs the issue of what the regulation should be, whether these non-lawyers should be subject to the same rules. So I just wanted to throw that out there. I mean, I understand it is for profit, but that's not I don't think that's the exact particular or appropriate response to some of these concerns.
I agree fully. I don't think anyone is at issue with the fact that it is for profit. I think it's more the fact that it's for profit, and if there's not a regulatory framework, then it would obviously lead. That would be, I mean, comparable to going to a hospital without any oversight or regulation, and I would not be a person who goes to that hospital.
And I just kind of want to point back out the idea that right now we have a very two-tiered all or nothing system. I would also not go into a hospital without oversight, but I would show up at the masseuse down the road for a $20 massage when my back hurts and not go to an orthopedic surgeon. So some of this is about building options that aren't always regulated. I think that's how consumers are able to then get everything that they need, because this is supposed to be about the public. And so I agree that the for-profit, I don't want to focus on that, but one, the reality of right now we have lawyers without the skill set needed to effectively and efficiently serve the consumers. That's why 2 hours out of a day are spent on law-related services in most law firms. So by allowing people to invest their skill set, their dollars, their things, we can actually increase the efficiency of those services that are being provided, which results in more services to more people and better services to better people. I also don't think that we should so kind of create this bright line in legal where law, it's lawyer and non-lawyer. Again, it goes back to the idea that we have this huge network. Nobody thinks of the medical field as doctors and non-doctors. We think of all of the various people who make up that, and that includes hospital administrators. It includes people who go out and educate the public. There's marketing around that. There's the pharmaceutical companies. There's so many different pieces, and we've just created a system where we say you're either a lawyer and the regulations are what save consumers from bad lawyers, or you're not a lawyer and you might destroy it in your process of helping. And I'm just asking us to be more open to all of the layers that belong there, because they are there. And when they're not there, when we create so many regulations so often for every single problem, we actually create a system that requires lawyers to do things they're not skilled to do, and doesn't allow people who have those skills to come in and provide the opportunity for them to actually serve that market.
Andrew, if it's okay with you, let's move on.
I say let's do that.
Okay, we're going to move to recommendation 2.2, which is B2. Add an exception to the prohibition against the unauthorized practice of law, permitting state-certified, registered, approved entities to use technology-driven legal services, delivery systems to engage in the unauthorized practice of law activities. Simon and Daniel.
Yeah, so actually, is it okay if I lump this in with 2.4? Because it's
Please.
Okay, great. So briefly, 2.2 proposes the safe harbor for UPL. 2.4 says, okay, if you've got that safe harbor, sort of legal services that they would under receiving those from a human being. So I'll jump into the comments in just a second, but just to pile on to some of the comments from earlier, from Joanna in particular. statements like that are really very frustrating to me. Anyway, I'll get off my soapbox now. So, as to the comments, there was a lot of misunderstanding, as I think we got in a lot of these different areas. But in this UPL area, there's misunderstanding specifically about what the proposed safe harbor covers. So legal information services would, as they exist today, like your, I don't know, whatever service you get from whatever sort of, Andrew, I'm just going to use this, a legal research service, for example. That's a legal information service. That's not practicing law. So that would continue to work today. Or work in the future. If you stray into the sort of territory of actually practicing law, and you don't have the safe harbor, you're going to get prosecuted. Yeah. Whether that's the EPA or the bar or whomever, if there's a complaint, someone's going to probably deal with it. That continues. What's new is something, and I kind of think of this as like something akin to like a non-prosecution. Like you basically get this agreement that says, you know, if your technology can get competent, if your technology can provide competent legal advice, that one over there, and the directors go through, you know, moral character review, and the entity is bound by the same rules as lawyers, then you're good to go. Unfortunately, comments like the one that Andrew pulled up, the second comment that Andrew pulled up from LACPA, they unfortunately didn't read that part before submitting their comment opposing and saying exactly what our recommendation was, so that was a little frustrating. They said, you know, if you're going to do this, you really need to make sure that the entities and the technologies are regulated at the same level with the same ethical standards as lawyers. And it's like, well, come on, guys, that's what we did. Like, that's what we proposed. So, yeah, that's a little frustrating. Okay, and so there was a claim this morning that lawyers are unique in being fiduciaries. That's inaccurate. Many other professions have fiduciaries. I'll just leave it at that. But in this vein, I think there are a lot of commenters that sort of they didn't read the full detail of the proposal, and so when we talk about areas like enforcement and fiduciary duty and competence, they kind of missed all of the nuance that we were trying to put into those. In one of the town hall meetings, we seriously discussed barring broad limitations of liability, even piercing the corporate veil and personal liability for the directors of the corporation. I mean, heck, we could even impose a corporate death penalty, yank someone's charter. Everything's on the table, I think, at this point. So there's sort of this tone of the arguments that say, well, you've got lawyers and they've worked really hard to get their bar card, and you know it's this huge thing, and they really want to keep it, and so they're going to perform ethically, and that's great. Yeah. Honk twice.
A response.
So yeah, so if you've got this bar card, you know, lawyers are very personally invested in that. They've dumped 3 years and $250,000, and you know, a lot of mental effort into getting you know that bar card. But let's see, where was I going with that? But all these other remedies can also be on the table for corporations, and I think we also need to look at sanctions. So if, for example, you have a robot lawyer, we won't call it legal robot because that's taken, but if you have a robot lawyer that files a bunch of frivolous lawsuits, you'd want to be able to impose some sort of court sanctions on that company as well. So I don't know what is out there as far as those rules, but I think we also need to sort of do some
Can I make a
investigation.
deposit and then get some checks?
Okay. So the next one I have, as far as the comments, corporations will profit while providing reduced quality legal services.
And it's $2, right? For the check?
I'm just going to talk over that. In many comments, like this one,
Thank you.
I noticed that the conclusion kind of doesn't fit the premise. But you know, as we just discussed, corporations will indeed profit. That's fine.
Is there a bathroom
It doesn't
in here?
necessarily follow that because of that, consumers of legal services will be receiving lower quality services. But that in and of itself is a legitimate concern, and the legal profession has addressed that through, for example, the duty of competence.
Yeah.
Hey, whoever's on the phone, can you mute? Thanks. And then to echo what some commenters said, there must be proper vetting of both the provider and the technology. That's exactly what we proposed. And weirdly, we got some opposition comments that said exactly what the proposal was. So I don't know why they were opposing that. Anyway, there is healthy skepticism of technology. I think that's important. I think it's wise to be skeptical of, you know, bold claims. Let's see what else. Oh yeah, and then finally something that didn't fit within any of the other sort of comments. For 2.4, one commenter mentioned that tech legal services will not suffice when lay people will not be able to decipher automated legal answers. And I think there's an important point in there that we haven't really addressed elsewhere. If an automated system tells someone who's not a lawyer like myself, you know, here's what you need to do. You need to go file a writ of mandamus. What? I don't know how to do that. When we adopt the language of lawyers and the systems adopt the same language, that's going to be problematic for consumers to understand how to actually take a legal action. So I think maybe we should think about a new recommendation that covers something around like the user experience of the legal service should be comparable or better than what we receive from humans. I don't know. We obviously need to workshop it a bit, but I think in there we can fit things like, you know, it needs to be an accessible service. It needs to meet at least the HD accessibility type. It's free of dark patterns. And that goes to, you know, some of the earlier comments this morning around doing right by your client. You know, if you're tricking them, if you've got this onerous click wrap or browse wrap agreement, that's not really truly consent. Well, in any non-legal aesthetic setting, that's not really consent. So I think we can sort of fit in a lot of the concerns, in particular that we've heard from the Consumer Attorneys of California group that has been pretty vocal about a lot of this, and they bring up some really good points. So I think maybe we want to think about a new recommendation around that. So I'll just put that to the floor.
Andrew.
Dan, won't those things get flushed out in like beta testing? Because if a company designs a product like that, nobody's going to use it, right?
I would hope so, but dark patterns unfortunately won't. So I think there needs to be some sort of higher standard where the regulator is watching over and has some teeth to watch over things like dark patterns.
Daniel,
Yeah, I had to look that up just now.
Okay, I'm
a
sorry.
little bit on what a dark
I had to look it
pattern
up just
is.
now, and I totally understand now that you've said it.
Yeah. Okay. So dark patterns. I'm sorry. Really quickly. It's like when you get the GDPR pop-up, and it says, you know, check all the boxes for all of the ad partners we want to share information with, and all of them are unchecked, or all of them are checked, and there's no uncheck all button. You have to go and individually deselect every single one. Things that sort of annoy consumers, things that, we saw this, which is now outlawed in California, but we saw this maybe a decade ago with auto billing. That's a dark pattern. The sort of monthly auto billing. Yeah. So there are a whole bunch of these different things that are just sort of, they're kind of screwed up to do to consumers. But a lot of the internet, a lot of startups kind of thrive on them. In particular, a lot of them exist right now around consent and data analytics. And if we're going to be introducing this really sort of sensitive data to, developers, we need to think that, well, this is data that's walled off. You can't touch this data. We need to make sure that that data can't be exploited at the expense of the legal consumer. So yeah, that's it.
An example from law could be like a really lengthy retainer letter that a client might not actually fully understand, and then they sign it. That could be a dark pattern because if they don't understand the legalese contained within that retainer letter, that's why we have the obligation to explain it, and if they speak in a different language, to ensure that there's kind of reasonable efforts to do that. So just as an easy kind of comparable example. We do even have issues as it stands with certain things like retainer letters, et cetera. So as a matter of fact, some of the things that we recommend could even help the status quo within the law as it's done with kind of ink and paper.
Well, and at one of these sessions, one of my co-panelists who was opposed to a lot of this stuff actually brought up my company's terms of service and pointed out a very sort of onerous limitation of liability. Honestly, I haven't read our terms of service in a while, so who knows there. And I think pulling things out like that, I think giving the regulator some ability to, if not mandate those things, at least suggest those things and giving it some duty to work with legal startups and try to improve the current state for consumers.
Tara.
Some of these things we're, not that we're hearing for the very first time, but we're hearing, I guess, in a different way for the first time. And I'm really, becoming more open to the idea of the sandbox thing where we can test out, I don't know what parameters are going to go in there, but where we can actually test out products so we can catch the problems. Because otherwise, these are words we just know, and any regulator, people implementing that, there's just too much. So I like the idea of testing it out because it's not a one-size-fits-all problem. And we definitely need to, this definitely needs to be part of that solution. That's all.
Joyce and then Lori.
And I think the other thing about the sandbox or pilot environment is it doesn't have to be, you could limit by areas of law, you could limit by specific activity, you could limit it by, there's, we've done a whole bunch of stuff around, I know I've mentioned it before, the name change, gender change marker tool in Florida, and that is a very, targeted to a very specific community to accomplish a very specific kind of thing. It is entirely free. The last metrics I have are for the end of June, and we've generated 67,354 unique legal forms that are county-specific, ready to be filed, and include process and procedure information needed to be able to file effectively in the court of jurisdiction that you are living in and that you want to file in. And so I think there's lots of, that's a really small.
And is there data about whether people are using it?
We estimate that if you go through the process of completing all of the forms needed to do the entire process from start to finish, which you can do on the site for a specific county, we just estimate as a rough number 75% of those folks actually file because it is arduous to get through, and we estimate that people come a couple of times before they complete the whole thing. Because you may not have all of the materials. We're getting better and better at figuring out what they need to do. But I think that's it's a proxy for, because we launched in the first quarter of 2018, and so I don't have, we're still kind of figuring out the proxies. But I really do think that there are, in the sandbox or in the pilot program, you could do really small, specific things that would reduce the potential for negative impacts or harm. But until you figured out things like, is there a way to audit trail that? How much data analytics can you really determine? And you could do one-on-one follow-ups with people that are willing to. I mean, it's a little harder for us as a nonprofit to sometimes do that kind of in-depth follow-up. But I just think there's lots of ways you could do really specific kinds of studies and tests that would be just incredibly beneficial in terms of the data you could capture.
Like a claims process to people who had problems or
Yes, yeah.
malpractice type issues down the road. If that was automatically being filtered, then we could go back and evaluate this.
Or if people go to file and the judge kicks it back and says, I've never seen this particular kind of form before, or you haven't followed the 1-inch margin around the file. I mean, serious, like those kinds of county-specific things. I think those are also really helpful because they tell you things about the process that isn't readily available. Because if we couldn't find it or figure it out, then I can guarantee you the self-represented litigant never figured it out, right? So those are the other pieces that come out of that. But I think having it be, in a limited scope like that it'd be super cool.
Lori and then Andrew.
I wanted to first address the issue of the fiduciary, I can't say that word, the money thing. Let's talk about that. I just want to challenge us all to think about how much of the legal education that lawyers receive actually involves how to manage money properly, since we've made that a duty lawyers have. But I'm not going to make assumptions about California because I've been very wrong about some of those before. So I want to be very, very open to hearing more about how we've prepared lawyers to own that responsibility. We've given it to them, but how have we actually prepared them to manage that well? And my own personal experience in Tennessee as a paralegal was essentially that lawyers gave me the responsibility with zero expertise or experience in managing clients' money. And my additional experience in legal billing was that I've never met a trust account that was right. In all the auditing over the years I've done. So I do want us to be very careful about this task force and not continuing a problem that might exist in this space and not sort of addressing that. Then I want to back up, and I've been very, I think, vocal about the idea that I'm not a fan of the sandbox idea because I think it's so limiting. I'm worried that I'm actually not as worried about how many innovative tech companies show up. I don't think I've been clear about that because I think the innovative, excited people who want to do this are going to jump right into the sandbox. I'm actually concerned about how many lawyers who are on the ground floor who are already meeting needs and struggling to figure out how to continue to meet those needs have either the time or the capability or the money to play in that sandbox. So I think we risk creating solutions and ideas that actually exclude some of the very people that we are trying to empower to provide more services by having a very limiting sandbox. So I just want us to be thoughtful of that. And then I also want to sort of acknowledge I may be changing my mind, and I'd like to hear more as we move forward on this in November. I have been very opposed to the idea of regulation generally. I think that's not shocking. But I actually like the idea of bringing in some proposals and regulations to improve the user experience. And so instead of mimicking what lawyers are already doing or providing the same regulation as lawyers have, we already know that's not working. Can we actually provide a better user experience and regulate that in a way so that we can help everybody accept kind of where we're headed, I think, on these ideas. So I'd kind of like to hear more about that, but again, from the user experience, less about maybe stopping all the bad corporations, but improving the user experience.
Andrew?
Very quickly, if we do a sandbox, I think we should also try to partner with and let the folks know who provided any of the feedback points throughout this process to participate in it, but also make it mandatory that through that collaboration that fixes to what is being proposed are also mandatory as part of kind of what they suggest when things aren't working. Okay, well, this would make sense, et cetera. And then also to ensure that perhaps we explore an idea for like a beta test with, oftentimes depending on new pharmaceutical products, there's the ability for people to opt into programs that haven't been tested, but their current situation is so dire that they are willing to make that assessment and opt into that. That could be something we explore as well, and then collect data off of those initiatives and projects. So it could almost be a limited sandbox with, bumper guards, but then also another area which does come with kind of clients and opting in, similar to what you would get with kind of an experimental drug program or treatment program.
Okay, Andrew and Daniel, okay to move on? Okay. We're going to recommendation 3.3, which is C4, adoption of a version of ABA Model Rule 5.7 that fosters investment in and development of technology-driven delivery systems. This is Andrew and Johan.
Thank you. First and foremost, it's important to note that recommendation 3.3 was conceptual, not specific, and it would presumably begin with the ABA Model Rule 5.7 with adjustments to come later that were intended to promote broad flexibility in financial arrangements among lawyers and non-lawyers in innovating the delivery of law-related services through technology. Because none of that was included, we have the same challenge where a lot of the comments were not really on point. With that said, we had roughly 100 comments with 90% opposing. The remaining 10% were between no stated position or supporting. Virtually all of the opposing comments missed the point that there were no edits to the ABA model provided and that the value would have been the safe harbor to the practitioners. We did look into this a little bit further. I threw a couple of interns on it, and of all the objectors, 19 out of the 20 turned out to be attorneys, and one just had a common name, and of course we didn't track down any of the anonymous statements. Now, a few of the opposing and no stated position comments, less than 10 actually, commented that the design purpose of the model Rule 5.7 would be moot, as California already has case law that provides for the parameters of when an attorney providing non-legal services to a client may be subject to the rules of professional conduct. This point is accurate unless or until any changes made to the model Rule 5.7 or adjacent changes would be made to UPL, ABS, Rule 5.4, et cetera. It would be noted that the comment was also delivered by several opposing commenters, presumably that were just against all changes. The opposition to this Rule 5.7, as it would be broadened, should actually increase the ability in terms of both scope and scale of all lawyers, as well as provide a safe harbor for all licensed legal practitioners, the definition on that to be determined, to venture toward increased capabilities. Basically, the uniform opposition just seemed to be just that, uniform opposition to pretty much everything. When we get into the specific comments, I took a little bit different approach on this. Because of all the repetition, we just did a couple of things. We had a couple of priorities. One, we wanted to restate the purpose of the rule, the addition of the codified safe harbor, and the absence of the impact to UPL. So we prepared literally one single response, uniform for all of them, which was that adoption of a version of ABA Model Rule 5.7 is intended to enhance the scale and scope of services provided to clients by a lawyer or a law firm, as well as codify a safe harbor for those practitioners. This model does not directly involve any relaxation of prohibitions against UPL. Now, most of the California State Bar's responses included responses to the peripheral topics that were included in the comments. We removed those entirely and felt that it was best to, or more appropriate to handle those in the contextual conjunction with the relevant recommendations that they were referring to. And again, just due to the repetitive nature, meaning that some of the comments were just literally the same comments from person to person to person. And so we just addressed them as such. A few of the commenters, and I only used numbers, but the 1062I and 1063I, which were organizations, draw to a greater context the fact that Rule 5.7 in any version has components that rely upon the definition of the practice of law juxtaposed with the delivery of law-related services. The proposed single boilerplate response statement does not address that issue of the applicable definitions, as the task force chose not to define the practice of law. But the point is significant, and I addressed it in part 3, item number 2. So in reference to part 3, and again, because of the repetition, what you'll find is I've summarized some of the comments so that we could approach them at a larger scale. The first of which was the fact that the bar or the court could be and should be doing something, fill in the blank, in addition or instead to making the changes that are present here. Now, there are a large number of opposed comments that read the court should be doing this, the bar should be doing this. And the problem is not with the lawyers, it's with delay, with funding, with time, whatever the case may be. The sentiment is correct and it approaches the justice system in a complex or holistic context. While the judiciary does, for example, have some initiatives investigating the benefits of ADR and diversion, as well as one that's $13 million committed to understanding the importance of video conferencing as it's applied to the handling of the judiciary. It has not broadened the scope of the task force to include the tangential or adjacent items. That said, the trustees and justices will surely consider the greater context. Therefore, it seems as the only error here was the lack of context given to the recommendations and their subsequent explanations. Were these explanations given, and additional context might have been drawn, the conflict away from a lawyer versus non-lawyer and more toward the efficiency model of administrating the judiciary. And with the inclusion, and I started to sort of redefine this because I didn't want this constantly to be landing on human beings, but it's the other than lawyer individuals, entities, and technologies. This context would be helpful in the recommendations across the board as they're finalized and delivered. Second point, and I know I like to open cans of worms. Mimi, would you do me a favor and actually bring up the diagram? Thank you. So I work better with visual models, so I actually went through and created a visual model of what I think we're talking about here. So I think we made an error by not defining the practice of law. I understand the sticky wicket that I'm talking about here, but I think it also would relieve a lot of the challenges around 5.4, 5.5, and eventually 5.7. And with regard to 5.7, because I did try to keep this as on point as possible, I think we need to add a third section, which is delivery of related non-legal services. The reason for this is because technology and some of the services that we're using are moving between what would be considered the practice of law, could potentially be put into the law-related services, and we have a number of services that I've outlined that are actually moving out of law-related services into related non-legal services. And so not only do we have this three-tier model, but the service providers from outside the legal industry can actually come into the legal industry and provide services at a high enough level of satisfaction that in all truth could probably not need to be regulated at all. And you'll see then that we have the tiers within, for example, law-related services of individuals, entities, and technologies. I do agree with, and this may come as a surprise to a few of you, that a lot of what LA County Bar has said and that type of thing, I do think the practice of law should remain essentially intact as it is, even with the inclusion of other than lawyers, individuals, entities, and technology, because it's a good model of scrutiny, even though it's passive as opposed to active. So some of the services that are moving in and out of here right now, for example, is language translation. In the last 2 years, language translation has surpassed the human ability. Matter of fact, I sent an email on this to the task force 7 months ago, and that email's wrong because the new information shows that they're actually even better. So Google Translate has machine learning instances, and you can gain those or gain access to those at a very low cost and actually be using those today in the legal industry. And because they're individual machine learning instances, they can continue to be trained and improve specific to the legal industry. So or justice industry, whichever you'd prefer to consider it. But this is really important. And then the other concept is that the simple or simplified law that we see with LegalZoom or TurboTax, because there's no interaction, this is where I say we can commoditize a lot of the things that are done in the courts, in the practice of law. I'm not saying we should do that to everything, okay? But I am saying that from the bottom-up perspective, we have that ability to very quickly and very easily bring those things to bear. Now, and those are ready today, by the way. Those aren't down the road. Those can be ready, use purposes defined as appropriate. Number 3, oversight of lawyers and enforcement of UPL by California State Bar Association is already very much in question as to efficacy. This is a comment brought up by, I think San Diego also had a group of lawyers, LA County Bar Association brought this up, and it's very relevant. Specifically, the supervision of lawyers is currently passive as opposed to active, not aggressive, in that a complaint must be filed before any review of performance, ability, or execution duties is examined. New technologies are defaulted to active supervision. This is really important. This technology is designed in the form of a panopticon. Remember, now, a panopticon means from a single perspective you can see all right, you got it, sorry. From a single perspective, you can see into every corner. You can see all of the data. So if we need the information, we can draw it out relatively easily. If we're taking demographics information, if we're taking decisions information, if we need any sort of divining information, it's typically already in there as long as it's designed to be input at some point. The leading piece of information specific to the Bar Association is not 508 compliant, not even close, okay? The leading website for the Supreme Court is not 508 compliant. Nobody's using the language translation properly, okay? There's only one state in the country that's doing it, and it's Texas, okay? California Lawyers Association is one of only 7 bar associations that's actually ADA compliant. This is really important stuff. With the recognition of these persistent limitations, the regulatory model is outlined in Part 3, Item 2, would place an emphasis on adoption and endorsement. And we got away, we've sort of gone off on this tangent of UPL, assuming that we're in control of everything, and I'm not suggesting that that's the case. I specifically referenced the ADR and the diversion programs that the judiciary is looking at, and in Los Angeles County alone, if we use diversion for juvenile cases, that takes 10,000 cases off the docket, okay? If we apply the same standard to adult cases, there's another 20,000 cases off the docket, okay? So we don't need more money, we don't need more courthouses, we don't need more judges, but we know San Francisco's already eliminated the juvenile hall, okay? It's working. We have these pieces that are doing very well, and they're handling huge pieces. Huge chunks of the demand. If we take those demands off the table, the rest of the system can work better. The clerks can handle the flow of information because you just got rid of 30,000 cases in one county. Okay? Really powerful stuff, I promise. Then I put in a bonus section because that's what I do. One of the things that when I'm looking at this, is I noticed that there were several assumptions that the task force was operating under that didn't get conveyed, and they didn't come back around in the comments. And I thought that they would be a really important response at the top level. So first of all, we all recognize the plus or minus 80% of the market that is not being served. Whenever I hear that baby steps or incremental improvement or any of these things are on the table, I wonder why nobody caught the other number, which is that we've quantified this gap for 25 years. If you had told me baby steps 25 years ago, I'd be all with you. I'd be absolutely for you, okay? But we're 25 years behind, We're at least 10 to 15 years behind in technology. So that's an important assumption that I think we have to make. Second thing is the justice gap is available nationwide, and I'm going to concede this point to the commenters that were opposing to us, which is there is no magical cure, right? There is no single model that we can point at and we go, they don't have the problem that we have, we should do what they're doing, okay? That is, however, not an excuse for not doing anything or for moving slowly. 3, I believe, and I'll speak for myself, although I don't think I'm alone in this, that access to justice is actually an obligation upon the court and upon the judiciary. It's not optional. There is no excuse that I would accept that, sorry, we're not going to give access to justice because we just don't have the time, or we don't have the energy, or we don't have the courts, or we don't have the whatever. I don't care. This is a triage situation. We don't leave anybody behind. We give them access, and frankly, if the courts need to change, I like you, Neil, I just met you. I feel like I'm beating you up, and I'm not trying to, I promise. If the courts need to change, then the courts need to change. They just need to move forward with that, and then we can get this done. Number 4, current technology is as good or better than human interaction, at least when you start at the bottom and move up. People talk about complexity. We had a lot of conversations about attorneys saying the work is complex, nobody will understand it, you know, you can't make the computers do this. AI has beaten the game of Go, okay? Go has 10 to the 172 power of options, and it can beat everyone except itself, okay? No human being can handle the complexity that AI can handle right now. And finally, 5, the prohibition of other than lawyers in the legal system place an unnecessary tiered hierarchical constraint upon the talent pool required for beneficial administrative efficiencies in the justice system. I can't encourage you enough that both the court and the bar have got to have technology experts at decision-making levels in order to be able to bring these things to bear. And finally, I honestly believe that at some point in the 25 years that this gap has been there, that gap has moved from being negligence to intentional. We cannot go slowly forward. We have to take a quantum leap. And that's all I got for you.
Okay. Can we move on? Oh, did you have anything to add?
Oh, yeah.
Yes, but not as much as that. I agree with about 90% or 95% of what Johan just said. But I did want to direct this kind of back to the public comments and our response to them. The vast majority of the public comments were not responsive to the proposal. And that's kind of the reason for the standard response. The public comments that we did receive seemed mostly like fear-mongering, and I don't know that very many of the people that responded to this particular proposal actually read ABA Model Rule 5.7 because it, in fact, adds regulation, doesn't take regulation away. And it also specifically regulates when lawyers, not non-lawyers, just lawyers, provide law-related services, not legal services, law-related services. So it's a rule that applies when lawyers are providing law-related services. So there's really not much of a nexus with UPL. And the benefit to the rule, we think, would be creating kind of a bright line with when a lawyer providing non-law-related services is subject to the RPCs, and an opportunity to carve out, if we want to include non-lawyers when they might be, non-lawyers or entities, when they might be subject to the RPCs. So I just wanted to kind of reiterate that. And I could pull out some of the specific comments as examples of not being responsive to the proposal, but I'm not sure that helps. In order to get more specific public comment, maybe we need to get more specific about what the change to the model rule would be, or what specific carve-outs we would propose to the model rule. And so I'm not faulting the public for submitting faulty comments. Maybe we bear the responsibility for making a proposal that is non-specific. So maybe we just got what we deserved.
Mark and then Neil.
I agree that we probably got the comments we deserved. I think that we put out a pretty detailed version of 5.4 alternates 1 and 2. We didn't say anything about 5.7, other than the fact that they take it to mean the ABA model rule, which is not what we meant at all when we proposed it. If we agree that the goal is to narrow the justice gap, and if we agree that there is no one single model, there's no one single solution, that it is a multifaceted approach, then there's a place for 5.7. Why is that? Because we haven't got it. We've never had it. Not every state does have it. The law in California in this area is a mess because most of the disciplinary cases involving what someone might describe as law-related services are not. They're dual professions. Dual professions is very different than law-related services. So if I'm a lawyer and I'm an accountant, all of the rules apply to me when I render those dual services to my clients. That's not law-related services. We have an ethics opinion. It's 1995-141. I know that because I helped write it. That's 20 some odd years ago. It's out of date. It is the only opinion that exists on law-related services. We wrote that because when the ABA adopted 5.7, California said, well, we don't think we need the rule, but we ought to have an ethics opinion. Well, we did. 1995 is the opinion. We now have a new draft that's out for public comment that is controversial, to say the least. And it's gotten some pushback from Office of Trial Counsel. So there's a big debate going on here between COPRAC that puts out this opinion, Office of Trial Counsel, and the public, and that's stirring up the juices. Meanwhile, clarity is not happening. And in this world where we're going to be, I hope, narrowing the justice gap by offering a menu of approaches, there is no doubt that lawyers and non-lawyers can get together in a combination of services that we can define, if we choose to do so, as being outside the purview of legal services for purposes of requiring only lawyers to perform them. We have the luxury, we have the ability to tinker with 5.7 to make it more user-friendly as one of the menu of choices, not to the exclusion of others, but just as a menu of choice. I can't imagine we wouldn't do this. I can't imagine because it not only is it a safe harbor for lawyers and non-lawyers to get into AI and a whole range of law-related services that if performed by a lawyer might involve the practice of law, but when performed by a non-lawyer, we all know is not the practice of law. We can think of 1,000 examples. Real estate agents, bankers, CPAs, TurboTax, all these people. This is why they're not practicing law, because they're not being performed by lawyers. So there's a whole range of services we can provide to consumers in this area. Again, not to the exclusion of other also solutions. So I can't imagine why we wouldn't. Last point is, I am in favor of consumer surveys. I'm in favor of getting information. I'm in favor of getting them what they want. But we also are the third branch of government. We also have a duty to provide the integrity of a justice system that people have confidence in, and that there's fair and there's constitutional principles, and it's not a market-driven profession. So keep that in mind as you're going ahead. This is not a market-driven exercise in itself. Thank you.
So just very briefly, and I know this group hasn't had the chance to see these comments yet, but Judicial Council did submit, after the September 23rd deadline, a set of its own comments to the task force recommendations and proposals. And in there, the council sort of makes clear that vis-a-vis the justice gap in the courts, the court's activity in setting up self-help centers across 58 counties, partnering with county law libraries to also provide self-help staff there, and also partnering with legal services organizations. So you'll see those comments. I apologize they came in late. They needed to go through our council's tech group, and so they're there.
Thank you. Lori?
I think someone tried to turn it off. I don't blame them. I'm curious about a couple of things on the idea of sort of really reinforcing that this isn't really, this problem is and should be focused on like courts solving it, right? Like putting the obligation back into the courts is a really interesting idea that I think we all accept, and we're all here because the court is looking for these answers, but actually maybe going a little harder and saying, hey, what's happening isn't working. So regardless of kind of how we end up on all of this, real solutions, real options, I think we can spend some time saying from a very different outset, because we are not in the court. I don't hang out in the court system. And so I know you guys have these conversations, and I know there's all these initiatives, but I'm sort of fascinated by the idea of why courts have not developed revenue generating models to help access to justice, because the court has a major funding issue. And so I believe that we can actually build court initiatives that are revenue generating, that feed back in to serve the same people that we're looking for. So I'm kind of fascinated by that, and I just wanted to sort of throw out, I'd like to hear more on that as we move forward in November. And then I want to kind of remind us as a group, I'm a paralegal. I was a paralegal for 15 years. Now I only serve lawyers, but I've been involved in access to justice, and I work with our court and its initiatives. I've rewritten ethical rules. I've been a major part of major initiatives for 20 years, and yet I have no idea what legal information I can provide to consumers without running afoul of potential UPL issues. So if someone like me, with my 20 years of experience in legal, working with lawyers and serving access to justice at every level, from the administrator who signed in the people at the legal clinic to rewriting the ethical rules and creating statewide initiatives for access to justice, doesn't understand what I'm allowed to provide in terms of legal information, that may be something for us to consider when we have sort of decided not to define the practice of law. Because what we're really saying is we leave things so ambiguous that people are maybe not coming in to offer solutions that don't run afoul of those. So I think it's more than just what can people do, it's also what is the perception that we've left that people, buy into. So I kind of wanted to throw that out there. Because legal information is not legal services, but we all recognize that legal information leads to a slippery slope that people are afraid of. And so I kind of like us to approach that with our recommendations as well, maybe.
Randy?
The team who handled this one raised something that, and apologize for getting very mundane, but there were many comments on the various recommendations that were essentially non sequiturs because they were railing against the entire project or talking against some of the more dramatic proposals, non-lawyer ownership or fee sharing, but they ended up in, should we define the practice of law? Should we have define AI? And the approach by staff so far was not to, completely disrespect those comments, but to say something back that sounds like you're talking about something else, and as to that topic, you should know that X. But the team here has come up with a single response that only really targets things that are pertinent to the particular recommendation, in this case 5.7, And we could take that approach across the board, and that would save tons of work. If we just ignored the comments that were off base or completely, neither here nor there, and only responded to things that were relevant to the particular recommendation. And I'm wondering, just general feedback, because ultimately this is going to be the synopsis of a comment that goes to the board and is available to stakeholders, if that's what you want us to do. If you want us just to be responsive to the point that's relevant to the individual recommendation, or to acknowledge that, hey, you're talking in this instance about non-lawyer ownership, ABS, but this recommendation really has nothing to do about that.
Kevin, and then Tara, and then Andrew.
Okay, maybe I didn't completely catch what Randy was saying, but I think what he's getting at is, yeah, we could save some time by just saying this is not relevant, your comment isn't relevant, but we do have a response to the concern you raised at such and such, rather than repeating that response each time. Is that what you're suggesting?
Well, it depends on how tailored or customized the responses are. If it's a general response to, say, an allegation about the proliferation of notarial fraud, which belongs under maybe 2.0 or someplace else, and it shows up with the 5.7 recommendation, then you can make a general cross-reference to the 2.0 table, and there'll be lots of responses to lots of those comments. So we could definitely do that. But it's whether we sort of repeat ourselves in that particular place is what would be the savings.
Okay, I have another comment, but it's a more general comment, and I'll just defer to everyone else first.
So Leah, do you have a reaction? I mean, is a cross-reference response
Yes,
sufficient?
I think we've heard a lot of feedback about how the public comments should be responded to, and maybe coming up with a new approach that differs from what we've historically done. And I think they're well taken. And if you would give staff some flexibility or time to come up with a proposal, and perhaps we could work with you, Justice Edmond, and the vice chairs to just come up with a model that is reflective, I think, of the sentiment of the group, which is it's not going to be particularly useful to have 3,000 specific responses.
And I think so long as there is a cross-reference response, as opposed to saying your comment is completely irrelevant, then I think that it would be helpful. So the answer is,
Non sequitur is a kinder word.
that works too.
Do we need a motion for that or no?
No.
No.
So
Thank you.
I definitely think part of it should be a general response, like we all kind of had when we first started this meeting, that, some of them were off top, sort of explaining that, that they were presented overly broad, that we never intended for it to be, wide open doors, and sort of I think it's a good opportunity to clarify some of the things that were unclear in the first place.
Well, it's the
And to give
education that everybody keeps
Yeah.
talking about, that it was never intended to be what it was perceived to be, and
Yeah.
responding and explaining would be helpful.
And I think that would be super helpful, and then going and breaking it down to the specific relevant responses, because I know we got some great ones, especially the organizations that I read were very thoughtful in their responses with very specific issues that we could address in practice areas, and I'd like those to be addressed.
Good.
If I may, that's actually why I put that fourth section in there, was because I think we have some basic assumptions that we can basically agree upon. I mean, truly at the basic level. And I thought those would allow us to sort of sum it all up, because I don't think they were as well communicated, or as the overview wasn't as communicated as to what we're trying to accomplish here. I absolutely get the challenges for the lawyer versus non-lawyer. I buy it. As much as I am on the tech side, and I want to get some things done and move forward, and I support 5.4 and 5.5 and 5.7 altogether. If we properly frame it, as Mark put it earlier, and I thought it was really well done, how does this come down to closing the justice gap, improving access to justice? And the assumptions we should have amongst us and agreed upon should be part of that.
Are we expecting revisions to the recommendations by November? Or are we talking about just looking at public comments in November and then doing revisions after? I think we need direction. Toby?
I was just going to, a couple of things that were said that triggered something, and you know, the discussion about the courts getting more money. Courts get their money from the legislature, but in fact what's happening in California is that courts are losing funding because they're eliminating fees and fines that in fact discriminate against low-income people, and that's diminishing the budget of the courts, not increasing it. So they're taking away funding, and that's a good thing. Not for the courts maybe, but certainly for society. The other thing is, I don't think it's the court's responsibility. I think it's society's responsibility. I think it's access to justice. I think it's not an issue that lawyers need to solve alone or that courts need to solve alone. I think it's a societal problem that the legislature needs to deal with, the administration needs to deal with, that the society as a whole needs to address. How do we make sure that those words over the Supreme Court about equal access to justice, or equal justice for all, in fact become a reality?
Kevin and then Neil.
Okay. Very briefly, as I hear this, and I heard a number of comments at the town halls, people equating access to justice to access to courts. And I'm not sure that's accurate. I'm not sure that's what this task force has been all about from the get-go. I think it's a much broader access to justice and provision of legal services, affordable legal services, to folks who can't afford it. I would guess most of us here in the room cannot afford to retain ourselves. I mean, we'd just be too expensive. So I guess to go back to the 5.7 proposal itself, I read the memo with interest, but I'm not sure that it really responded to the proposal or any of the responses that were actually on point. And primarily the response, I thought that was, or I should say the public comment that was most relevant to the recommendation or tentative proposal, whatever you want to call it, was that California law is much more complex in this area. As Mark mentioned, it's not so much complex as it is confusing, and a rule might be able to straighten that out. But this memo didn't really address that. So I think we have to at least address those comments that were relevant to 5.7. This went off in a whole new direction, which is focusing on access to the courts. And I think the types of legal services, law-related legal services that could be authorized under Rule 5.7 go well beyond that.
Will you just, Neil's up next. Will you just remind me what we did on the Rules Revision Commission with respect to 5.7? Did we have a draft of something to look at? Did we talk about it and decide not to go there?
We didn't have time, and the first commission spent hours on it and didn't come to any conclusion. By the time we got to the second commission, the time did not allow us to get into it, and it was easily decided we'd have to just pass it over. So we didn't give it due consideration.
Neil, and then back to Mark.
Just really briefly, just to follow up on what Toby had mentioned. The other thing I'll point out too about the courts and trying to fill the justice gap is that in addition to what you mentioned about issues relating to fees and things like that, in the first two budget cycles after the Great Recession, the branch's budget was cut by $1 billion. $1 billion. And that included rating funds that certain county courts had been saving to build new courthouses to increase access. That's something that the branch has not recovered from until just very, very recently. And now you are now finally seeing new funds being dedicated towards building these new courthouses and funding new judgeships. So just wanted to point that out as well.
Mark.
And let me build on that for a second. Chief Justice George had wonderful programs in place for court facilitators and the like that all kind of put on the sidelight. But I think Toby's comment raises another issue, and I really don't want to get in a soapbox about this, but there's a very serious issue of jurisprudence involved in this entire discussion that we're having. It isn't just access to the courthouse, it's access to justice. It's not, you don't trigger the rules when you walk across the threshold. It's in the back room, the boardroom, negotiations. It's almost everything that the legal profession does. And there is an integrity issue here. It's not a market issue. There's an integrity of the judicial process that's at the backbone of everything we're talking about. And you can't buy it, you can't sell it, and you can't market it. It's what we do. And lawyers are responsible. No, the courts, no one comes to defense of the courts but lawyers. We haven't done it, and we need to get on it. So it is our problem, and we haven't done it. We've failed, and it's for a lot of reasons, market-driven mostly. But the legal profession has not lived up to its responsibilities in terms of protecting the courts, getting the court funding, access to justice. It really is that's why we're here. So we can't duck this. We can't say, oh, it's a court's problem. Or it is a legal problem. And we need help from a lot of sources, but the buck stops with us, in my opinion.
Okay, we got Andrew and Lori, and then we need to wrap it up and talk about sort of where we go from here, not having made a dent in our agenda today. So, Andrew.
I think it might be helpful, Randy, to just, I kind of second the idea of general answers and rather than each one, and then perhaps the answer could be, see section 1, section 2, or section 3 of comments above, because we can kind of just put them into general themes, and then perhaps we can say, hey, if there's any more questions, there's an additional kind of thing or other resources. But I think that that's the best way to do it, or else even we couldn't get through our agenda today because of that.
Lori.
I also agree with the general response. So I think that's a great way to efficiently move through this. And I just want to go back to kind of addressing what Toby said about it's society's problem. I agree wholeheartedly, Toby. But I also have to point out that you have built a system that locks out everybody but you. So you cannot say this is a societal problem and then not allow the people who are ready to join that fight to somehow partner with you. So I think what I'm hoping we can do as we kind of move through this discussion, I wasn't actually suggesting on the court side that we increase fees. Creating a revenue generating service means maybe a really low cost service that people are happy to pay to have some access from the court. They would trust it more, is my bet. I'm actually suggesting models like TurboTax and things of that nature, where not everything from the court has to be free. And people are very happy. I can go to a low cost sliding scale therapist to help me with mental health issues. And I recognize that they are not profit driven, but that by investing some amount of money that I have into what they're doing, they can continue to help people like me. So I just want us, as we're crafting our final recommendations, to not get so bright line, black and white, that we don't say, hey, courts, I think you guys can offer services that do increase access to justice through legal information. That doesn't necessarily mean access to courts. That is a cost, a low bono cost that helps people get more access in all kinds of ways. So I think it's one, I still think courts can make money that is reinvested because those budgets are going to shrink. And we can't do anything about that. And two, if we're going to make it, if we're going to get more people in the fight, we have to change the rules to let those people in the fight.
Okay, Randy, let me toss this into your lap. It seems to me that there was sort of universal agreement that we need to perhaps go to the Board of Trustees and see if we can get some relief on this, what I think is a somewhat arbitrary timeline that was initially adopted. Now that we know what we're really tackling here and trying to get some relief. So we will do that. And in the meantime, Randy, before we know what we've got in terms of time,
Sure.
can we talk about a timeline about what we do between now and the November meeting?
Okay, so just speaking for myself, with the volume of comments we received on all these proposals, it's almost impossible and impractical to say that one person could do a good deliberative review and study of every single comment that's come in. In my office, I have staff who have assisted in reviewing each of the 16 recommendations and the comments that have been received, helping me identify the recurring comments, helping me to find things that stand out as being sort of fresh thoughts that haven't been considered before. And with that assistance, I've been able to get somewhat of my arms around the entirety of this. But I'm not going to try to ask the members of the task force individually to try to appreciate the entirety of the comment. And so the process that we've begun, even though it sounds like we have a bit of a reprieve on the final work product in terms of the public comment table, I think still needs to continue. And so we're going to try to get, what's a realistic date for a completed master comment synopsis table?
Some will be sooner than others. I would say.
So,
I don't know, I really can't say because I'm
okay.
in charge of all of them.
Okay, so hopefully by the end of next week, we will be able to turn around the so-called master table that gives you a glimpse at every comment that's received on an individual recommendation. And ideally, if there was teleconference or video conference meetings between now and November of each subcommittee, then as a subcommittee, you can look at that, you can identify any other recurring points that need to be fleshed out, as well as those key comments that do warrant sort of a tailored reply and might even lead to changes in the actual recommendation. Because when we get to November, if we stick to the same game plan that was used when we had a December deadline in front of us, we'd only have a very short subcommittee breakout in the morning. We'd have maybe an hour for you, each subcommittee, to get together your final thoughts and then take a turn and make a presentation in the afternoon or later in the morning and also in the afternoon on the recommendations that came out of your subcommittee in terms of, from your subcommittee's perspective, would you change a recommendation? How would you modify it? Would you advance it as is? Would you try to combine it with something that came out of another subcommittee? But once we hear from each subcommittee as to how, if they were in charge of the final report and recommendation of this task force, how they would fall, because I've played that game in my mind. I kind of know of the 16, I think I might even shared something with Leah, where some things might go, how they might be handed off for further consideration. But I think each subcommittee ought to do that as well, because then when we get to the full session in November, there'll be at least 3 different views as to how we can homogenize the 16 recommendations into a final report. And I think if we have that, we'll probably be in good shape, because I can't imagine that there wouldn't be some overlap, that each subcommittee might come to the determination that, the definition of UPL might not necessarily have to be a recommendation. It could be just a finding and report. And so I think by the end of the November meeting, we'll have a little bit of a better idea what those final recommendations might be. And let me just tell you one thing that I've toyed with in my review of them, is that if you have things that are overlapping or competing, and so, we have 2 versions of 5.4, I think it would be too much of an assumption to say you have to necessarily pick between them. Because after the Rules Subcommittee looks at them, the Rules Subcommittee may come up with Alt 3, and Alt 3 might be what they actually say is something that could be advanced to the board, handed off to COPRAC or some other rule drafting body to implement. So don't think sort of in the box in terms of, well, we've got fee splitting versus ABS. One of them will have to go. We can only keep one. Let's wait till we get to November to see what happens. Professor Stephen Gillers attended the public hearing. Many of you were here. In his written support for Alt 1 of 5.4, he didn't kill Alt 2. He said, Alt 2 is very interesting. It's very broad. And consent models possibility, but that might not be the starting point. You might want to start with something like Alt 1, reserve consideration of Alt 2 until there's some sort of track record with that change in the law and see where you go. So when I start thinking about the 16 recommendations, I'm not thinking of killing anything necessarily just across the board. I'm thinking of prioritizing, combining, that sort of approach. And I think if we do that in November, we might not have 16 things that were a menu. We might have 10 things that are actual full-on recommendations. And maybe some of them say, do this first and do this second. And what used to be competing recommendations are now prioritized recommendations.
Okay, Randy, let me see if I can, if I followed what you just said. Between now and November meeting, we'd like each subcommittee to have a conference call in between and talk about this issue of sort of where do we go from here, and might we want to tweak the recommendations?
Yeah, with due consideration of the fact that at that point, we're hoping you will have in front of you access some sort of guidelines as to what's in the entirety of the public comment, so that you're making these decisions about the recommendations without leaving out any comments.
And Leah, can we come up with an Alt 3 at this point without sending it out again for public comment?
I think so, because I think it's
We're not
safe to
approving
assume
anything.
there will be a further public comment. Obviously, there would be before anything could move to implementation. I wanted to raise, and I know it's almost 4, Randy and I have had a little internal debate about this. I'm sensing a little bit of frustration among the task force members about the process, and I'm wondering if there's continued utility in the subcommittee structure as it's currently organized, or if it would make sense to transition to a model that was more thematically structured. So that, for example, we did start grouping together options that are related, and having the broad themes identified by staff for that group of options. And that was the way that we then moved forward, as opposed to the subcommittee process, because I think there's a lot of overlap, and we're not sort of advancing the bigger policy issues in this format.
I think that you sense right. I think everybody does feel a lot of that. In that more thematic approach, do you see every grouping being addressed by the group of the whole, as opposed to breaking down into subcommittees?
I think so. Again, Randy and I, we had a little bit of discussion about this ahead of time, but I think it would mean there might not be any calls between now and the November meeting. There's a lot of staff work involved to structure the November meeting so that we can come back with these broad sort of themes: non-attorney ownership and fee sharing. And if that is related to the alternative business structure, we fold that in. These are the themes, these are the issues. What do you want to do, task force? Kind of be able to talk about it in that way at the November meeting. It's a different organizational framework, but I think it might help move us forward.
Tara.
Would it be too much for each member to put together a half page with what their thoughts are and submit it to the task force with what their vision would be? Because I tend to agree that the subcommittee is, I love them all, but part of the problem is that we've been isolated in our subcommittee, and we've been like, we want to hear more. And so this was great. It's taken the public comment for us each to hear our respective ideas, and I don't want to further isolate, because we're just going to sit in that room going, well, what's the other committee doing on fee sharing?
Mark.
I agree with that, and I would add that in the Rules Revision Commission, it was effective if certain groups were assigned as presenters to present a certain recommendation or certain aspect of the report, and they're the presenters. They come prepared to present it, but the group as a whole hears the presentation and then comments on it. I think that's very effective.
I love the idea of members of the task force sending staff just your general thoughts on where you are. I think that could inform sort of the framing that we come up with for the November meeting.
Is that optional?
Yes. How
What'd
can
you
it be
say?
mandatory? You
Oh.
can't implement a rule
I
directing
think that's
you
a
to
great
do that.
idea as well, and what I would suggest is that you try to do that sooner rather than later. All of this is now fresh in everybody's mind after hashing it out all day, and so, and particularly, it is gonna take a lot of time and effort to get ready for that next meeting. So if you could send that off, say, within the next week.
And if you do it, my request is do exactly what Leah just said in terms of if you think certain recommendations fall together and could be assigned to a certain group of members to lead the discussion, what would be the ones you would put together? Because they are now grouped by subcommittee, but they're not necessarily grouped by their topical or thematic content.
And you can even volunteer as to those things that you want to cover.
It would be useful, and I know more work for staff isn't what you need, but just a quick email to the commission, to the task force, saying, here's what we want you to include in this half page. Just a reminder to us, because we'll walk out of here and forget.
That's a good idea. The only final issue that I think we all agree that modifying the responses to the public comment is a good idea, and so we look to you all to do that. What about the survey? Is that something that we should wait and look and see what sort of timeline we get from the Board of Trustees, if any, and then figure out what the right timing is?
What is the date of the November meeting of this? Okay, so it's before the board meeting. I think it would make sense for us to at least explore the survey, the cost, come up with some proposed questions for you all to consider on the 6th. And then obviously we wouldn't execute any contract before the board took action.
Perfect.
Okay.
Okay, what else? Anybody have any questions? Let's do one more round of applause for this wonderful staff. Where's Mimi?
Including the staff that's not here.
Exactly.
I got to run. I'm
Lauren and-
out of Burbank, so yeah, it's tight already.
Thank you so much.
Yeah, thanks.
Thanks, Neil.
Yeah.
Hello.
We got plenty to do.
They're trying to get your attention.
I think he needs you to announce. Adjourn.
We need to announce that we're adjourned? Okay, we're adjourned.